Greetings, loved ones.
Hey, everybody.
Nice to see those beautiful faces.
Okay, so today's class, we have some news with respect to where we left off from last class. We reviewed last class, and although it was well done, in our opinion, we're not going to release that one, and we're going to release this one. And there are a few elements as to why we made a few changes with the paperwork that we're providing to the court. And as such, this process of layer and layer and layer and layer, it puts us at a bit of a, I'm not going to say a disadvantage, but again, I have to have like, very forward thinking perspectives where I don't like putting out the paperwork and then 2 days later, I thought of something new, or here's another variable, or didn't think of that and it needed to be inserted. So over the course of the last week, we have made those alterations, these upgrades, and we will be implementing those and sharing with you all those today.
So we have a stacked class, as Dîevergence always does. I see some of you have your notebooks out and your pens. We love it. Take your notes. This class, how we've designed it, is so that you can stop and go it when you wish. It's probably going to be one you have to watch a couple times just because of the layers of wisdom that we've inserted for beginners, for intermediates, and for our experienced equity lovers among us. So what we're going to actually do next class, just a little bit of a heads up, we're going to start the class 10 minutes early for those who would like to join us for an equity quickie meditation. It was a meditation that Darren and I brought in that has very high frequencies. It speaks to the energy of equity and also to the higher powers so that you can just release your day, you can get present, because you need to be in order to keep up to these kinds of classes.
Any little advantage we can provide and share and help everybody with, it actually has a cumulative effect, and it actually does have a positive impact. The lifestyle that we all lead, we know how hectic it is, and moving forward, we need to get to this place where we have a little bit of peace of mind. And we found over the last several years, without finding your little safe place where you can relax, absorbing all this knowledge is much harder than you might think. Imagine doing all of this with no distractions. That would be an ideal environment. Unfortunately, very few of us, if any of us, have that opportunity. So again, any little thing that we can do to help out, we're going to try to do our best.
So again, we're not going to be releasing equity class number 4, but equity class number 5 is going to give you a nice review of what we did talk about back then. And we're going to also, again, layer it. So first of all, we're going to give you a summary of the new upgraded process that we have for our loved ones who are up against banks and creditors, their defendants who maybe had their property seized or confiscated. Their property is subject to foreclosure, or they received notice from a sheriff of an upcoming foreclosure or seizure of property. So this is going to really help those who are about to lose their homes or their vehicles.
Or children.
Or children, absolutely. This is going to help you be able to breathe and be able to feel a little bit safer, even though we're in this legal world. Number 2, we're going to talk about the new upgraded entrance requirements to join Dîevergence class proceeding. We have streamlined the process. Again, why we're not releasing class number 4 into 2 forms, something called our AAA, which is a form AAA called the Ascending Administrative Agreement. This has entrance require questions that you have to answer. It also has a place where you can put your security certificate. So it's nicely streamlined for the administrators and trustees moving forward. And Form 70, which is our notice of interest. This is taken from the Supreme Court Civil Rules. If you go in there and look up Form 70, that's actually what we took so that any members wanting to join the class proceeding, we can attach your interest to ours. And we have a little bonus today. We're going to be talking about equity versus common law. We hear a lot of individuals speaking about how they've been studying common law. Now, while we do encourage that, we're going to be showing you another side and another element that you're going to definitely want to give some due regard to in order to find the remedy you're looking for. And in typical Dîevergence style, we've got pop quiz questions throughout. So please join in. It doesn't matter if you're guessing. The whole point, what Darren and I are looking for, is participation. We don't like idle acts. We don't need wallflowers here. We're trying to find the lions that are out there that are wanting to learn this and be able to get out of these yokes that we have around our necks.
And don't feel bad if you do find yourself guessing a little bit more frequently than you may wish to be. But you know what? Hey, that's all part of this game. You'll find that the more eyeballs you put on this material over time, the repetition, oh, this way, that way, upside down, reverse, the more you're exposed is going to allow you the ability to actually absorb this stuff. As Jody has mentioned in the past, I've basically been saying the same thing for 3 years, just different ways, which is ironic. You know, if you consider the scope of what's going on, how could something possibly be talked about so many different, you know, from so many different perspectives or versions? But it's true. Again, once you understand a couple dozen words and some basic, oh, I shouldn't say basic, some phraseology and some terminology, you're laying in bed going over this stuff at nighttime before you go to sleep. You're in the morning in the bathroom brushing your teeth and it's still rolling through your head. That is you being exposed to a level that we're hoping for so that this becomes priority. Yes, you can, you know, you can do your daily life, but in the background, you got this other operating system rolling. And through repetition, you'll eventually just be having, oh, and those little light bulbs that go off are a massive feeling of accomplishment. Or when you do get some of these questions right and you didn't guess, those are the little, you know, the little pat on the back because you've made progress. When the more you're making progress, again, we're trying to encourage a positive feeling with this, not a strict, demanding, there's, you know, for at all costs. No, where we're trying to remove the significance and the strictness and encourage humor and a little bit of fun and a little bit, oh, I didn't think of that. And again, we're trying to make this so that, you know, someone that's 12 or 13 years old could literally start to grasp some of these concepts.
And my last phase of training, which you'll see even in our AAA, has been wrapping my wings around the court forms and how to do my own paperwork. You can ask this man, I've said over and over, I'm not going to coattail through this. I realize that he's the class representative, but I want to be able to speak to this myself. And so it was through this learning and going through the rights and the wrongs of it that I was able to find my way in that. And the court forms is one of the hardest parts, I believe, right after learning the terminology and what all of the words mean. And you know, Hollywood depicts superpowers as being able to throw bolts of lightning and fire and being able to move water. What if the superpowers were be able to control the public and the positions that are in power so that we can have a very different life than we know? What if that's the superpowers we're all craving and know that rightfully belong to us? So this is why when we're developing these court forms right now, I'm very much a part of it. I try and stick myself in there as much as possible, mainly because I'm trying to learn this.
And the best way to do that is here, take a blank form and go start inputting what you know and what you don't know. And then again, I'll come in on the background and just fill in the blanks. But when you jump in, that's what puts you into that situation that forces you to be your best. And it's that particular test. If you can be disciplined enough with it and not cut corners and not just go and, oh, Google this again, because I can't remember what beneficiary of a something, all this, this is what is going to make us arise, ascend, get to that level of consciousness where, again, we can all be a class representative if you wanted to be. This isn't about, here, take all of this stuff and then just, you know, go up into the hills and grow your vegetables and play with goats. That's not the direction of our class proceeding. Yes, we provide that ability, but again, we're looking for individuals who are spiritually and mentally aligned and are here to do incredible things globally, and not just for yourselves, but for others. It's that charitable incept is, I'm going to say it's paramount. It's the number one thing that we're trying to share with everybody.
So we're trying to teach you some superpowers, loved ones. And so with that, let's start with the question. Pop quiz, get in the chat. If you are sharing a computer, that's fine. If you can actually put in the chat what your answer is and what your partner's answer is, that would be great. But this is a beginner question. We're going to start tagging the questions with either green, orange, or red so that you know the different levels of questions that we're asking. That'll give you a good feel for the Trusted Life Training program coming up. Question number 1, common law is the law of fictions and persons in adverse possession. Is that true or false? Let's see your answers. Okay, we've got a true, we've got a false, we've got a true, we've got a true. Okay, thank you, loved ones. The correct answer is true. Very good. Let's build on that. Question number 2 is the system of jurisprudence called equity was originally largely derived from the common law of the Romans. True or false? The system of jurisprudence called equity was originally largely derived from the common law of Romans. Okay, we've got a false in there. We've got a false. I'm gonna wait for some of you. We especially want to see from our subclass members. This is all part of your record of involvement. So let's see what you got. Okay, we've got a false, we've got a false, we've got lots of falses on this one. It's false. Let's go into this. The reason for that is because it's from civil law, not common law. You're going to find this in Henry R. Gibson. If you are new to equity, or if you even are experienced and you do not have this reference, write this down. It's Henry R. Gibson and Suits in Chancery, 1907. It is one of the most fascinating books to just get lost in.
Henry Gibson, he was a chancellor. So this guy knew his stuff. He was a handful of gentlemen from, 100-ish years ago that really laid down the foundational principles for people like us 100 years later to pick up those pieces and do what we were meant to do. Here's a weird twist to this whole story. Back then, these guys, these chancellors, they knew what the public was trying to do. They knew what the common law was trying to do. They knew the adversity that was coming. They knew the strife. They knew the suffering. They knew all that bad stuff was coming. Equity couldn't stop it, but equity has always been here in the background to help us with a way out. Now, Henry Gibson, this book is a little bit challenging to read. I'm not going to lie. It's a little bit like Shakespeare. It's a little daunting. But again, this is why having that fundamental background with some of these words is going to play a significant part in you comprehending what's truly going on here. So I'm going to say that this particular book, this particular version of Suits in Chancery, this is the go-to manual. It's about 1,200 pages long.
That's all.
Give or take. And I mean, the book, there's not a lot of double spacing. This book is jam-packed. I know there are other contributors out there. Joseph Story is another incredible one. There's a bunch of them, but this particular book, if I had to pick one, it would probably be this.
We love this one and we reference it often. You'll see it throughout this class, in fact. So what you need to know is common law only deals with legal. But we know we need to have the merger of equity in there to be able to extinguish the legal. And this is why we also need to study civil law. We also need to study equity. Okay, so here we go. We have to read some of this because this was a little bit further down in the book as far as the differences between common law compared with the civil law. And notice what it says. Common law, it has certain rigid molds or formulas in some one of which wow. Like we said, it's a little bit of a tongue twister. Let's try that one more time. It had certain rigid molds or formulas into some one of which every cause of action had to be cast. And if the cause could not be run into any of these molds, there was no redress. And if it could be run into one of the molds, only such redress as the formula gave could be had, regardless of the equities of the case and the real rights of the parties. The fictions, formalisms, and arbitrary technicalities of the common law and its dialectical refinements were inexplicable and incomprehensible jargon to the public, and often a costly mockery of justice to the litigants. Those who asked for bread were often given a stone, and those who applied for a fish sometimes received a serpent.
But equity, on the other hand, disregarded forms, ignored fictions, subordinated technicalities to the requirements of justice, and indulged in no dialectical refinements. Its pleadings were so simple and natural, and its doctrines were founded upon the eternal principles of right, righteousness, and interpreted by a lofty Christian morality. Its great underlying principles and the constant sources, the never failing roots of this particular rules were the principles of equity, justice, morality, and honesty, enforced according to conscience and good faith, and so adapted to the requirements of each of these cases and the complications of business affairs that the rights and duties of all the parties were fully determined. What is this saying? This is saying that the common law, at law, public law is immoral, it's without justice, and it's literally a waste of time. There you go.
So, not very favorable. So when we're actually looking at the deficiencies of common law,
Just quickly look.
35.
35 deficiencies, really?
This is where common law cannot help you. For number 4, a mistake or an accident. Number 5, a debt could not be assigned. Number 6, a resulting trust could not be set up. Number 7, a beneficial interest in property could not be enforced. 8, a void instrument could not be canceled. Specific performance, we're going to skip down here.
So everything we need, you can't do in the common law. Okay.
Number 25, a cloud could not be removed from one's title. A subrogation could not be obtained. Trusts were not recognized and could be violated with impunity. Notice number 30, a wife's equities did not exist.
Period.
Ouch. Number 32, an injunction could not be had in any case or for any purpose, however great the wrong. 33, receiverships were unknown. Number 34, equitable rights and interests were not recognized. And number 35, frauds could not be adequately remedied.
So why would anyone waste their time in common law other than to say, hey, let's just go for a little swim, but we're not going to be here forever? That's not the point of the common law, but it is interesting, the dynamic between the two. And you do have to do a little bit of investigating, a little bit of digging in the common law to get your grounding, to get your first position settled. Okay, that's all great. I mean, that's how Dean and I and many others did it. We first got totally entrenched with common law for like 10, 15 years until we finally stumbled onto what equity truly was. So I'm not going to say that was a waste of 15 years, but it was probably a waste of 14 years.
Okay, let's review a question from last week. Before you can take a beneficial interest or equitable entitlement in property, you must first perfect your interests. So before you can take a beneficial interest or equitable entitlement in property, do you have to be in equity? This is an intermediate question, true or false? Okay, we've got a true. We got 2 truths, lots of truths. Very good. That answer is true. Now we're going to build on that a little bit. So this is going to be a beginner question. Equitable defenses and security entitlements can be heard in a court of law or a court of equity, or B, it can only be heard in a court of equity. So this is a little tricky, but what do you guys think? Is it A or B? Okay, we've got a B, got an A. Okay, the correct answer is B. So anything equity has to be in equity. If you want to claim rights or entitlements in equity, you need to be of equity. You have to have a disposition of interest as well, which means you cannot be in possession of the person. So that means you've accessed your life estate. You have clean hands Again, you can't come into equity with dirty ones. This is further explained in one of the maxims, he who comes into equity must come with clean hands. It says this maxim declares that a complainant who has been guilty of unconscious conduct or bad faith, or has committed any wrong in reference to a particular transaction, cannot have the aid of a court of equity in enforcing any alleged rights growing out of such transaction. The Court of Chancery was regarded by the ecclesiastical chancellors as a temple into which no one could come except those who had clean hands and pure hearts.
So let's just talk about scripture for a little bit. You know how Bible's talking about the temple, accessing and getting into the temple, and how only the high priest was allowed into the temple? Can you imagine that little tabernacle box? What if that, you open up that box and ta-da, there's equity. You had to be of a certain caliber of a man or woman to get into the temple to access the equity. The public was not allowed. That's why the equity was protected. And the temple is actually a very, very important part. Again, when we're talking ecclesiastical chancellors, that's not public. That's all spiritual creator father stuff. This is pulled right out of scripture. It's important.
So as long as the record shows that we're the person, the debtor, the volunteer surety, we had a question on that on the chat, and the trustee, if we are up against banks or creditors' loved ones, they are what's known as the beneficial owners. We talked about this in class number 4. They own the property, and that's why they can come and seize and confiscate and repossess it. So we can't underestimate the magnitude of the mistake that we made when we identified as persons and we received the mark of the beast. And you'll notice in scripture, it talks about the mark was on the forehead and on the hand. Because not only is your mind consumed with the person, but you need your hand to legally transact. So very interesting about that as well. So this isn't an easy fix. This is not something like we said that you can just take a little paragraph from us and put it onto your birth certificate and all your problems are solved. You're going to have to roll up your sleeves, loved ones, and make time for this. And that's why we admire so much the individuals that are here or that are watching this recording afterwards. So we're going to build a little bit more on why common law fails when it comes to fixing our problem. And we related this to breaking your femur and what kind of remedy you would prefer. When you're looking at, you have the option of common law, that's comparative to only dealing in band-aids and persons in adverse possession. Imagine trying to heal a broken femur with band-aids. Common law is no order, it's outstanding, it's in issue, and it's possessed of imperfect titles.
Okay, so what does that mean in a nutshell? It means until you or reverse engineer these problems, if we're only operating legally, we don't have a chance of getting to the promised land because that legal system will not recognize anything that we're trying to do. So again, why would we even waste our time there? Well, coincidentally, we did waste a lot of time there. But if you're going to break your leg, you're going to want to fix this thing properly, not go to a second, third-rate doctor in his garage with no equipment in the dark and no rubber gloves on. Just don't do it. Trust me when I say that we've spent enough time in that dungeon to know that just don't even go there. So equity deals in, now when we say casts, we're referring to a process that's going to heal us specifically and properly. And I mean 110%. The equity will leave no stone unturned. It will leave no problem unresolved or no issue left outstanding. Let me keep going.
Yeah.
Okay,
sorry.
so equity only deals in casts for the living, the man or woman who are not in adverse possession. Divergence, we are offering, splints and proper methods to get yourself back on track, depending on your preferred way of learning. This is going to fix the problem. This is going to put things back into their original position, the upright position, in order, in standing, and possessed, if you will, of the perfect title. When the legal system deals in imperfect titles, which means they're not perfect, equity only deals in perfect titles. Again, Christ, our brother, was perfect in all regards. That's because he had a good, clean title. He wasn't stained or sullied or filthy and dirty with anything common law.
So just remember that analogy and let's focus on fixing this problem as soon as possible. Now, to prevent a multiplicity of suits and to avoid wasting court time, we want to put out this notice and give you knowledge of the following. Number one, Dïevergent5 equitable defense process that we are about to release here with some special news against banks and creditors is to be completed in full, not in part, please. This is not something where it's a patch job where you put some of your stuff in there, especially your terminology. Please avoid that, especially if you've been studying common law. This is where many of those ones struggle because they want to insert certain words. We've done some things here that is going to eliminate that.
I've literally spent tens of thousands of hours surgically developing paperwork, putting the right words in the right places to build certain momentum, certain things. And there are words that I do not use. So if it's not here, you might want to question putting it in. If not, no, don't do it at all. Again, the court process, they want things to be concise, which means very specific, very to the point, and no fluff. No colorful language, no emotions, things of this nature. And really, when you start to boil this wisdom down into a concise language, it doesn't read proper. It doesn't read like the bedtime stories grandma used to read to you. This has a technical format and it feels choppy and it feels awkward, but that's because it's efficient.
Number two, the remedy that we're going to be offering these loved ones, you can use it anywhere around the world. That's what's nice about it. However, should you choose to proceed with this remedy, no further assistance or direction is going to be provided by Dïevergent5 for non-subclass members. So if you want to go and do this remedy and you're not joining the class proceeding, if you get feedback or anything along those lines, we just won't be able to assist you any further.
Because that turns into a vortex, that turns into a black hole for us and we just can't come out of it. We are trying to lay down a format or a process to encourage people to come along. We're doing a lot of the heavy work, a lot of the lifting for ourselves. Now, if you take some of what we're showing and you want to combine it with some of the other things you think you know, I'm going to suggest that you may be opening yourself up for more controversy, more problems, more confusion. So you need to, I'm not going to say humble yourself, but you need to be able to just let go of some of those old teachings. Don't be attached to them is all we're saying.
Because if you knew how to do it, you wouldn't be here. So that's the whole point. We're teaching you how to do it. We've done so many different processes. We know what works. We know what doesn't work. And this is why, if you don't know how to do it, join our class proceeding. And we're strongly encouraging that.
And I don't mean to be a bit of a dick here right now, but again, I see on Facebook, YouTube, all the social media giants, other loved ones who aren't really following what we're doing and the things that they post. Oh, look at my magic remedy. It's like, I look at some of this stuff and I just laugh. But I shouldn't do that because I used to be in that position 10, 20 years ago.
And they're trying.
And they're trying. And that's what's important. And I will just once in a while, I'll throw a comment out, for example, on Facebook. But again, I can't be absorbed by just trying to teach everybody on Facebook by continually inputting what I know into their lifestyle, their dynamic situation. We're just trying to put something out there and encourage and invite them to come here.
And so moving forward, that's why this process that we're about to talk about for banks and creditors is not for subclass members. Because of the process that we're doing with you, this won't apply to you. So if something happens between now and the class proceeding being certified, as far as a notice or a seizure from the sheriff, please notify us, okay? Because you'll get some hands-on walkthrough.
So we've specifically kind of developed a little bit of a paper format for court purposes to help people who are not part of our subclass. So we're actually going out and trying to be a little bit charitable right now to show people, hey, look, we're just trying to help as many people as we can and to tickle some of the imagination and you know, the spiritual connection for people to get them to come and learn more. Yeah, you could probably take what we're about to show you and get yourself out of a mortgage, but then that's it. You may have solved your mortgage problem, but you haven't solved the rest of your problems. So again, just trying to provide a little bit of breathing room, a little bit of help for as many people as we can.
So you might say we're giving you a really big Band-Aid, okay? So let's talk about equity of redemption. There's some people that have never heard of the word equity, and they don't even think it exists. Well, here it is in the Trustee Act under persons who may apply for orders. Any order under any of the above provisions for the appointment of new trustee, subject to a trust of the above provisions concerning a chosen action, subject to a mortgage, may be made on the application of any person beneficially interested in the equity of redemption.
Two quick things. Chosen action. What does that mean? Okay, chose is the French word for thing. So this literally in English would read things in action. That's what chose means. Okay, I know that was a little bit confusing for some. Secondly, any person beneficially interested in the equity of redemption. Remember in Jody's mortgage documents that we showed you 2-3 classes ago, where it said on the very first page, about halfway through, it said this. What is
Go
this?
for it.
Go, you.
No, you were talking about
Okay,
it.
so this is out of the loan agreement, the mortgage agreement. You consent and also acknowledge that we may offer you a line of credit and or a mortgage loan as nominee and or agent on behalf of another entity, the beneficial owner. Okay, and that we may assign your line of credit, mortgage loan and or registered mortgage charged to a beneficial owner, whether or not such beneficial owner is named in the agreement. Okay, so what did that just say? That just said the beneficial owner is named in the agreement, but we're not going to tell you who it is because we want you to abandon all your shit and make mortgage payments for the rest of your life. But you see how the bank is actually being somewhat honorable here? Yeah, they're kind of hiding it, but they put it right there in front of you. Wow, okay, so who's the beneficial owner? It's not named in the mortgage other than who's the mortgagor? Who's the one borrowing the money? Darren Clifford. That is the beneficial owner. If Darren figures out his shit and comes back and asks for it, which nobody ever does.
So the equity maxim of equity will not aid a volunteer. We have to remember that. This is where equity and the angels, all of the higher powers have to step back. This is why they've all been absent for so long, because we all walked into Egypt, to Babylon, and they can't access us there. So this is why we need to dispose of that and get on the right side. Now, how the birth certificate evolves on its way to perfection. This is an experience question. However, we have been dropping this quite significantly in our last couple classes. So the security certificate, which you know is your birth certificate, is called what before it's credited to the securities account, and called what after it's credited to the securities account. So is the birth certificate called a financial asset before it's credited and an investment property after? Or is it called investment property before it's credited to the securities account and a financial asset afterwards? Let's see what you think. Okay, we've got a B. We've got a B. A B. There's a reason I built this question in. This was something I learned, and whenever I learn something, I make a question out of it. Okay, it's pretty much straight B's. This is probably why you guys want to learn this too. It's A. So the evolution of this is it's a birth certificate or a chattel. Then we specially endorse it.
It's okay, say that again, but put security certificate in there. Okay.
Well, specially endorsed security certificates after birth certificate.
Yeah, okay.
Yeah. So then it's specially endorsed security certificate. Then once it's delivered, it becomes a financial asset. And then once a security intermediary deposits it into our securities account, it becomes investment property or something known as an equitable asset.
So there is a chain of events here that, as Jody was suggesting, this thing does evolve. It grows, it becomes more powerful and more capable of doing more stuff. So again, you got a chattel, a certificated security, then it becomes a financial asset, and then it finally becomes investment property. Once it's investment property, that's when you're able to do stuff. As a financial asset, okay, if I had my birth certificate with me, I would have shown, I could literally take my birth certificate, put the assignment on it, write my name on it, there. This is a financial asset now. But what good is it sitting on my kitchen table, like I like to say? A financial asset is useless unless it's credited or forwarded to a creditor so that they can deposit it. Point being, when this thing evolves and grows, it kind of takes on its own little superpower, actually. So
look at what an equitable asset means. This is taken from Black's Law 6th edition. All assets which are chargeable with the payment of debts. So once you've got investment property, it's in your securities account, then you can charge things to it, remember, for extinguishment. It doesn't fall under the description of legal assets. These portions of the property, which by the ordinary rules of law are exempt from debts, by which the testator has voluntarily charged as assets, or which, being not existent in law, have been created in equity. They are so-called equitable assets because they can be reached only by the aid and instrumentality of a court of equity. And because their distribution is governed by a different rule from that which governs the distribution of legal assets.
So we see the significance here, loved ones, of getting that thing converted, getting it into the proper hands, getting it dropped into the proper securities account so that you can actually now discharge the debts, bounce public common law debts off of that account so that now you can beneficially use and enjoy any property you wish.
And the more you charge to equity for extinguishment, the more we bring down the public debt. We have to extinguish that and bring it over to equity.
This is what makes it in the public interest. This is why the courts must put this through. As we all know, every country in the world pretty much right now is plagued and drowning in debt. Why? Because no private citizens are coming forward with the ability to charge debt to a credited securities account. And I'm talking for hundreds of millions of dollars, if not billions, and eventually trillions. This is eventually how we pay off all the national debts and get our countries out of receivership. And now your brothers and sisters, your neighbors, everyone's going to benefit. This is where we literally lift the spirit, the consciousness of the planet.
And we deal with credit, not dirty money anymore. That's what's going to be beautiful. So we know of loved ones quite near to us that don't believe you need equity and don't believe that you need a court to fix this problem.
Even Dean's one of these people. I was talking yesterday, the day before, and he was still telling me, you don't need court to get this fixed. And I'm thinking, oh, yes, you do. Absolutely, we do.
So here's the thing. How can you be a sinner and not face judgment?
Judgment at the temple. Here's what Dean actually said, was it the other day? He said something about the cherubellums on either side of the gate, one with a flaming sword and one with maybe a shield of some kind. And he said, once you understand those principles, then you'll be allowed into the temple. Well, I'm not going to disagree with that, but the temple is the court. The temple, the priest is the judge. We're coming forward asking for judgment, believe it or not. Scripture says, hey, look out, judgment's coming for all you sinners. We're
like a thief in the night.
We're coming forward and actually saying, please judge me, please judge me. And again, we're going to define here what judgment means in just a moment, and it's not quite what you think.
And so our question is, if it's not equity, if it's not a court, then what changes the record and returns us back to life?
Yes.
Please, someone, please step forward and correct us, because we can see evidence of equity in the court serving us, and greatly, and to our advantage and to theirs as well. This is a win-win for all parties. So anyone we feel who's not willing to face judgment in a court of equity is showing clear evidence they're still a sinner and they haven't repented. And I know we say some things to kind of rub you, and there's a reason for that. We're not trying to poke you, but we are trying to shake you. Some of you, we need to wake you up. You're under a sleepy spell. And many of us have been sleeping or programmed incorrectly, and these are not beliefs we want to hang on to. They don't serve you.
And don't be worried if it offends grandma, or if it pisses your dad off, or if mom doesn't want to invite you for Sunday dinner anymore because you're doing all this stuff. You know what? You have to not concern yourself with others' opinions. If you do, you're not really meant to be doing this stuff. Make it easier on yourself.
We do attract by nature a lot of black sheep, which we like to call white sheep.
And I only say that because mine and Dean's dad, he was really against what we were doing. It literally broke our family up. We were removed from any inheritances, blah, 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 blah. It destroyed our family life. But you know what? Dean and I didn't give a shit because we know this is way more important and the world with us and you and others needs this. I couldn't give a shit what my grandma said.
And that's the difference between
So there you
3D family and 5D family. So this is why we wanted to lay a little bit of track down as far as what happened on last class, because bottom line, if you need immediate relief against creditors right now, here's your options. Perfect your interest and access entitlement to your equitable estate on your own and using Dïevergent new Form 1, our notice of civil claim.
Okay, so just let me expand here real quick before we get into it. Last class or the class before, we were talking about when the sheriff comes knocking, you know, here, give him a notice of seizure or a writ of possession or a writ of delivery, this type of thing. That was scratching the surface of what we're supposed to do. This is an upgrade. You're about to see it.
Massive. We did all the work for you.
Rather than just hand the sheriff a writ of delivery or possession, we actually cranked out an entire notice of civil claim to hand the sheriff instead, which is way better. And it's going to show the court, well, okay, whoever John Smith here is about to lose his house, this guy knows some stuff. And you're going to see just by the language that we're using, how it's instantly going to put you into a favorable position and you're going to smile. Even though you might be thinking you're going to be losing your house in 2 weeks, once you see what it is we're going to lay out for you here, you're going to be able to sleep a little bit better.
And you just fill in the blanks, you push print.
Again,
you do your research. This is not something you just print off and throw into the court, because rest assured, the judge is going to ask you some questions.
I don't want to call it a template, but guess what? It's pretty much a template.
You'll see. It's a template. So anything in red, these are the upgrades that we have done. This was the primary reason we're not releasing class number 4, is because we're no longer giving members the ability to be able to send their security to the court in Vancouver. The reason for that is because you have to be approved before you can join our class proceeding. So we don't want securities being delivered to the deputy registrar before the accompanying paperwork is attached to submit it onto our paper.
And this serves a couple of purposes. If I can catch a flaw or a deficiency somewhere, somehow, we're going to do it and correct it and get it online now, rather than our registrar sending it back. Again, trying to be efficient, trying to get us into that better position, quicker the better.
Let's do a review of a question from last week. This is intermediate. When making claim to any rents, proceeds, profits, and accruals of property, that is you accessing your life or equitable estate for set-off. So this is a little meaty. You might have had to be at last class to know the answer to this one.
And if half of you are going to guess, don't worry. Don't feel
That's
bad.
okay. So what do you think? So these are equitable entitlements that we all are entitled to in equity for any extra things that occurred on these different instruments that are out there. So when we actually claim this and receive these entitlements, is that us accessing our life estate? Okay, I'm not getting any answers on that one. So we're just going to move on. The answer to that is false. We had some loved ones who wanted to do this process, and they were under that impression that when they made these claims, for these huge amounts of money, that this was them accessing their estate. And in fact, it's not. And this is why we want to help you understand that there's 2 different perfection processes that are going on here as it relates to you redeeming your birth certificate. So number 1 is in part, perfection in part. This means that you perfect the matter or the debt at hand. So this is the sheriff's coming for your house or coming to take your vehicle by disposing of the collateral in part for discharge in full satisfaction of the amount owing.
So again, they're going to come seize your car unless you pay $30,000. Okay, well, we're going to suggest, okay, you can assign $30,000 worth to this particular instrument and give it to the creditor or whoever's knocking on your door, and they are going to go and deal with it and collect that $30,000. Does that mean you accessed the whole of your life estate and have unlimited funding? No, you only get to do part. So you can see in part or in whole. These are two processes, as Jody mentioned, and we're going to give you the in part process right now. And our subclass and the class proceedings, that's the whole. Okay, so we had to do a little bit of distinction here for people.
And so individuals who are going to take this process in order to redeem those entitlements from those instruments and legal transactions, you have to be in equity. You have to have perfected your interests. So what the remedy we're going to be showing you is to get you back in your house or to help you keep your home. You don't want to be disposing of it in whole, because otherwise your certificate, that's going to take care of the mortgage or whatever you're up against, but then you can't make any other claims.
Yeah, then I would literally have to undo what you just did and reopen it so that you would get access to the whole. So again, it's all these little nuances and all these little things that people don't know, that I'm not going to say I know it all, but I know a lot, enough to get the court interested in what it is we're doing here.
So make sure you understand that if you take this to court, it's not like you're going to be getting millions of dollars here. You'll be able to keep the home. The home will be set off. Now, experience question: when making claim for total discharge of an instrument, such as a mortgage, you can ask for additional proceeds from the collateral, including charge a service fee. So this is something that we have heard, is that you can actually attach a service fee to this or ask for extra funding under different titles in order to get extra money. Is that true or false, loved ones? What do you think? And subclass members, again, we're going to give you a friendly reminder. We need to see your answers, please. So what do you think? Can we ask for extra money? Can we charge the creditors a service fee for our time? Okay, so we've got some trues, we've got a false. Okay, loved ones, the correct answer on that is false. So when we break down the meaning of proceeds, you can find this in the Personal Property Security Act. Anything in yellow is after you've perfected your interests. Anything in green is before you've perfected your interests. So remember, we talked about twisted legislation. Here is one such example. Look at how it's all mixed as far as different parties and pre and post perfection. So when it comes to post perfection, so you've perfected your security interests, this is when you can ask for compensation of loss for the proceeds or redemption for the investment property. When it's pre, so you're doing this in part, this is for a total or partial discharge of an instrument, such as a mortgage, based on the rights that are arising out of the collateral that you are going to be submitting here. Okay, so we hope that helps you.
So just let me expand on this for a quick second. I know there are many loved ones out there, and again, my brother is one of them. They want to charge a service fee for everything they do under contract, essentially. For example, Johnson's Towing towed my car the other day, and that's my private property. So I'm sending them a bill for $25 million to tow the car, and then an additional bill for $500,000 a day for every day that they keep the property. I'm suggesting that we don't want to be doing any of this kind of stuff. That's what we may call old technology, or a process that back in the day sounded like a good idea, but I'm going to suggest that we shouldn't entertain and we shouldn't go down that road. And here's why. It's going to boil down to this. When you can't profit from your own wrongdoing, where do you get the right now to charge X amount of dollars, 000, all these zeros? So it may feel like it's the right thing to do, And it may feel like, yeah, but now I'm not volunteering. I'm going to demand that they pay me for my time. My response is, okay, where's your time being spent? Are you serving Father Creator, or are you serving another entity? If you're serving Father Creator and you want to be paid, I'm going to suggest that's a misaligned thought process. We should be doing all these charitable works for free. If as soon as we want to start attaching mega dollars to things, we've missed the boat. And here's why. It's more critical, it's more important to tap into that credit credited to your securities account, because that's virtually unlimited. If you have that in the background, why do we need to be attaching $500,000 to Johnson's Towing Company, who's only doing their job? Who's only taking instructions from either the court or the sheriff, who's also only doing their job. The court is doing their job because we haven't come forward with clean hands and perfected our shit yet. If we don't have clean hands, where are we going to ever have the jurisprudence to tell a court, hey, I'm entitled to $25 million because Mr. Johnson towed my car the other day? It's just not going to work. There's better feasible approaches that are going to be less conflicting, less confusing, less arbitrary, less is going to be more. So
we actually received a video from a loved one who the sheriff came to his home and was saying that the court order was not signed by a judge, and so it was illegal and not valid. So we actually promised we would address that.
The judge, and here's I don't want to break his bubble, but the judge doesn't even need to sign it. It's true. Why? Because the system, the court, the judge, the process knows that we're guilty, essentially, of fraud. We have dirty hands. We are carrying imperfect titles. We're volunteer sureties and all that good stuff. So instead of saying that the sheriffs here are about to take my house or my car and that's all illegal, no. When they gave you 30 days notice to fix your problem, and if you didn't, and they're coming now to repossess the property, now's not the time to complain and throw insults and say, you know, you owe me $500 million. No.
Or you have no right.
Yeah,
Stop saying that. They do have a right. They're the beneficial owners. They have a right more than anyone.
Yes, and here's the problem though. In the common law, in the public system, they are the beneficiary. If you come forward in a common law court and say, yeah, but I'm the beneficiary, that's going to cause confusion. And guess what the court's going to do? It's going to rule in favor of the public. You are not the beneficiary because you've provided no evidence, you've submitted no proof, and you've got no bona fide claim to back it. If you did within the 30 days, the sheriffs wouldn't come calling to take the property. And this is what we're going to help you do right coming up here quick.
So part of the process that we're going to be showing you here is going to require an endorsement. We talked about this and we want to refresh you because there's an endorsement that has to go on to the birth certificate and some legislation that will have to be applied. Now, when it comes to an endorsement under the Securities Transfer Act, it means a signature that alone or accompanied by other words is made on a security certificate in registered form or on a separate document for the purpose of assigning, transferring, or redeeming the security or granting a power to assign, transfer, or redeem the security. So for, again, our subclass members, this is not applicable. This endorsement was actually provided on the AAA under the original terms, which we'll be showing you here in a minute.
So again, when it says on the certificated security or a separate document, the separate document is the AAA. You signed it right there. We're literally saying, okay, this is the other document and here's the birth certificate. You put the two together, now the judge can read it. Now we can see it. Now they can move forward. Why are we doing this? Well, some of us only have the small birth certificate. Some of us have the larger one. Yeah, that's great. But I'm going to suggest, instead of trying to write everything out on the birth certificate, we can get by just fine writing it on a separate document.
Here's what you have to write. We get asked this all the time as far as how do I endorse my birth certificate? Here you go. In accordance with the Securities Transfer Act. And we put our, that little box there that will identify which Security Transfer Act we're using. Chapter 10, notice absolute assignment in part made by the appropriate person to the Minister of Finance in right of. This is where you're going to have to enter your province or your state. Assignee for the purpose of credit to the person's securities account made subject to Rule 23-4 subsection 9, whereas assignor having acquired a security entitlement under Section 95(1)(b) of the Act.
That is a loaded paragraph. Almost every word in there has significant meaning, and it's all done with purpose and intent. Now, I'm not saying this is the only way to do it. I'm just saying this is a good way to do it. This gets the job done. This addresses the problem, provides a remedy or a solution, and puts the proper secured party into possession of the security interest so they can credit and get paid as well. Again, our whole process here does not involve not paying the people or the parties who should be paid. No, no, no. As a matter of fact, we're more about here, take everything you need and a little bit more. We're trying to be generous. We're not trying to be sticklers.
Now, there's a notice at the bottom of this. If you live outside of British Columbia and you're not a subclass member, you can't use the legislation above. You have to find comparable enactments or rules for your own area. The only time you can use BC legislation that we're quoting is if you don't have equivalent legislation or rules in yours. And in which case, then the Interpretations Act, number 8, remedial enactments, that will actually offer the remedy that you can attach on there.
That's just, it's like a boat. You put certain legislation in the boat, it sails across the ocean, it arrives in Australia, you go to the boat, you pick up your legislation from British Columbia, and you bring it into the court in Australia. They will do it. We've done it with other loved ones in the past. I just want to bring your attention here to quickly to where it says here, subject to Rule 23-49. If you go research in the British Columbia court rules what that particular number is, it's incredible. I don't want to let the cat out of the bag. I just go do it right now, but you're going to find it provides the mechanism for what it is we're trying to do.
So make sure you stop the video if you have to and write that down. Another common question that we get asked is, how do I sign? Here you go. You can sign any way you want, and then you need to print your name normally under your signature and put entitlement holder. So here is an example. You can put assignor, sign in blue. We'll be talking about the significance of that in a moment. You can print or type your name below. We've included the option of doing a red thumbprint. Dîevergence is known for this. We have a red pad where we put our fingerprints on everything. It has a certain feel to it.
What's the point of this? Well, here's what it is. This is literally drawn from the Sedeke Act from 1666. Okay. The plaintiffs or the complainants are proved or appear to be living by their action for recovery. So unless you're coming forward with a claim to recover what was lost, you're not deemed to be alive. What's an easy way to prove that you're alive? Well, look there, a thumbprint. Attaching a silver coin, well, that sort of proves that someone's alive, but that's not yeah, you used it, you attached the silver coin, but that silver coin is not intrinsically yours, but your thumbprint sure is. Again, just another little element that proves to the court that we are alive. Is it critical? Will this process fail if you don't do the thumbprint? I'm going to say no. This is still going to work, but this is just one more little element that proves that we're living.
And
again,
it looks really cool too.
Again, proof or we appear to be living by our action for recovery. It's actually recovery of mean profit or immense profit. Mean profits with interest. Once that happens, title revests. What title? We'll talk about that.
Experience question coming up. The passing of a consideration in equity passes title, and whatever the form of the transaction, if no consideration passes, in equity, no title passes. Is this true or false? We hear a lot about you don't have to attach valuable consideration, so we wanted to address this. So what do you guys think? Do you have to attach valuable consideration in order for title to pass? True or false? Okay, we've got a true. Come on, loved ones, let's see what you got. We've got a true, we've got a true. We see a lot of paperwork and we very rarely see valuable consideration. We've got trues and trues. Good stuff. That is correct. You can go and look this up again at Suits and Chancery under equity looks to the intent rather than to the form. At the bottom, it says, hence, it is the passing of consideration and not the form of the collateral.
Contract.
Sorry, wow, contract that in equity passes title. And whatever the form of the transaction, if no consideration passes in equity, no title passes. Now, hold on one second. See the number 12 there? In Gibson's, it will reference little numbers. And if you look in the very fine print in the bottom, there's so many golden little nuggets down there. Look at this one that we found. Under in equity, no title passes. It says, this is the reason a purchaser without valuable consideration has no equity.
Let's
So,
just take a moment.
mic drop.
Just take a moment to absorb that for a second, please. See what's going on here. If you're only doing common law, if you're only doing legal, you're not going to be able to pass a legal title to anyone properly. That's the whole debt creates debt, and nothing's being discharged because no title's effectively being passed. That's one of the great deceptions that the legal public school system has taught us. And, fortunately, we're here to avail ourselves of all that problem.
Further evidence. Number 73, under priorities and equities relating to liability of purchasers. The first two paragraphs, this is the first introduction of what it said. When the owner of a legal estate conveys in good faith his interest in it to another, and the acquisition of equitable interests. So this is all our kind of language. This is why we wanted to read this to you. It says, courts of equity recognize no inequality based on form or mode of creation, provided the equitable interest is perfected and is based upon a valuable consideration. The following rule will aid in determining this question. Number one, the equitable interest created by a trust made upon a valuable consideration is superior to the equity arising from a mere voluntary transfer or from the satisfaction of a pre-existing debt.
Okay, so when did we merely voluntarily enter and transfer something when we were about 14 years old? You see what happened there? Yeah, that's that social application. That's where we all got stung. That's a mere voluntary transfer going on right there. No consideration changed hands. So therefore, how could titles have passed? See, no, it didn't, which is why it's easy for us to come forward now and fix that problem, should we choose to do it.
Okay, so we have a question as far as replacing some of our words. Can we replace appropriate person with protected purchaser coming in as settler and replace it with equitable entitlement holder?
Yeah.
Even though we've not leaped over to that status or standing just yet.
Yes, but here's the difference. The appropriate person is defined. We have that kicking around in some of our stuff previously. An appropriate person is a person who, or a man or woman, who is entitled to issue instructions, directions, and orders.
Securities Transfer Act in the definitions.
So the appropriate person is also is prevalent or important because the name on your birth certificate must be you, which identifies you as being the appropriate person to negotiate this certificate. You're the appropriate party with this certificate. Can your mom and dad do it for you? Yes, but they would have to come forward and claim to be the appropriate person, because as far as that certificate is concerned, only Darren Clifford is the appropriate person to negotiate this thing.
Next question. Choose all the answers that apply to valuable consideration. So if you're a little new to this, is it referring to blood? B, gold or silver? C, the transaction signed love and affection? D, is it a silver-backed postage stamp? E, is it a good old-fashioned spit and handshake? Is it F, A, B, and D? Is it G, B, C, and D, or H, all of the above? Now, this would normally be a beginner question, but we make it intermediate by asking or giving more options for answers. So it'll complicate a few things, but let's see what you think. Is it blood, gold, silver? Is it a signature saying love and affection? A silver-backed postage stamp? Is it a handshake? This is a little tricky. Okay, we've got lots of G's coming in. Okay, anybody else? What do you guys think? If valuable consideration is necessary, you got to know what you can use and what you can't. Okay, lots of G's. We have just blood for one. Okay. All right, here's the correct answer. It is blood. You're correct, Georgia. It is gold or silver as well, and it also includes a silver-backed postage stamp.
So back in the day, before the legal system took over, they used to be able to convey land to each other through love and affection. All you had to do was put love and affection. You literally write it right on the paperwork, because only men and women are capable of love and affection. A corporation isn't. So that's a distinguishing characteristic. Another thing I wanted to throw in here, yes, a $1 American bill also passes title. It says so right on the bill. But for our intents and purposes, it's these three. The blood again is equivalent to the red thumbprint. That, is equivalent back in the day. If you didn't have a pan or a burnt stick with charcoal on the end of it, you could chew on the end of your thumb and stick it. Okay, well, that again is proof. Now again, ideally, this is all done in front of witnesses. That plays a large part in signing and conveying interests. But if you don't have witnesses, these are some of the valuable considerations that you would want to consider to attach. Now, this $8 Canada grizzly bear stamp, this is one of the special silverback stamps that we talked about. This stamp, when you buy it from the post office, it literally has a reference and a serial number attached to it. And you peel that off. You don't really stick that onto the document, although you could. It's not going to be fatal. But those little reference and serial numbers go back somewhere, and they're traceable to silver backing this particular stamp.
Real from the earth. And when you actually send the document registered mail, you can put the sticker at the very bottom. So this is something we sent just in February before we decided to go back to court. And this is what some of our stuff looks like. We like the thumbprint. We like to build boxes. We like to get the post office to get the stamp in there to be able to prove that, hey, it is now out of our possession. And we actually sign in gold as well.
Some post office clerks maybe didn't have their coffee today. And if you ask them to put the post office stamp in the box and they say no, do not throw a hissy fit. Do not swear up and down and I'm going to this and I'm going to charge you $500 million. No. Go to another post office. Even if it is a little inconvenient, I run into this situation continually. Depending on, again, this is why you roll in with a smile, be cordial, be polite, compliment the lady, all these good things, butter her up, get her ready to do something her boss maybe told her not to do. Because you may run into that situation. Again, is it fatal if you don't have the post office stamp there? No.
But again, it looks super cool. So what we're trying to say is take your birth certificate, specially endorse it with what we told you to put on there.
Original terms.
Put on some kind of valuable consideration, photocopy it, and then you're going to put that on the back side of the notice that the sheriff sent you, or you're going to put on the back side of form number 1 that we're about to release.
Darren, can I stick a stamp to the birth certificate? I'm going to say, you know what? Stick it on the other document instead. A silver coin, tape that to the birth certificate if you want. And the registrar, literally, they unpeel that and they will literally send the silver back or do other things with it. We've had every variation happen. We've had courts and clerks keep the silver. We've had them move it somewhere else, and then we've had them return it. So it all, again, I don't know, maybe that clerk didn't have their coffee that day either, but they literally take a photocopy of it and they sent the coin back. And they said this, if the judge or the court requires.
A suggestion for you, or that said the silver coin cannot be included in your attestation. A suggestion is for you to have a picture of the coin in the attestation and present the actual coin if and when required to do so by the court, or enter it as an exhibit during the court appearance.
So it's not a big deal. Yeah, we want it to move the legal title back to the real legal owner, but be prepared that they may send it back. Again, they're not really entitled, they're not supposed to keep it. Remember, the silver coin is just, it's like a carrier. It's like it's like a basket. It brings the title to the recipient, and then the recipient sends the basket back to where it came from. No big deal.
So again, don't underestimate the power of being able to put the copy of the endorsed security certificate on the back of the notice or on the Form 1. The public is not allowed to see the backside of documents.
Yeah, did you know that?
That's for private only.
We've literally I've been in court where I wrote stuff on the back of paperwork and walked into court and held and gave it to the sheriff. Sheriff took it right to the judge, and the judge is looking at it. And then I asked him a question 2 minutes later, and he said, I don't see that. I don't see that. I don't see that. And I was like, what do you mean you don't see it? It's right on the back. But I was in a public court. The public can only see the face, this side. They don't get to see, this is the back side. This is the public, or sorry, this is the private. This is the back door. Public doesn't get to see this side. And we've had a story where a judge, a chancellor perhaps, sitting in equity, wrote a court order, I believe it was 14 pages long, in handwriting on the back side of a document in all lowercase letters in purple ink. There's got to be some significance to that, or else why would the judge have done that? Point being, is it going to be fatal if you don't do it? No, but remember, every time you send in a public document, you got 50% of your paperwork is being unused. So you can use the back sides of paperwork only if you're going into a court of equity with clean hands.
So a couple more questions, and then we're going to show you this form, because this is stuff that you need to know once you do this process. This is going to be a question you're going to have. What's the best way to deliver the notice of claim to the sheriff? Do you mail the notice to his home address? Do you B, wait outside of the court and jump on him and serve the notice to him or her? C, do you send it by registered mail to the court? D, do you send it by regular mail to the court? Or do you send the notice using an independent courier to the sheriff's place of work? What do you guys think? How do we get this information to those that need to see it? Okay, we've got some registered mail, C. We know most of you are on phones, so you can't answer, but it's good to have those participating. Okay, the answer is you want to send it by registered mail.
Here's another option. Knock, knock. It's me, the sheriff. I'm coming to take your house right now. Oh, I don't have time to registered mail it to the court. What should I do? Put it into the hand of the sheriff. That is another way to do this. So the registered mail is important over regular mail. Why? Because you're going to get a receipt. When you have a receipt, that's proof of delivery. That's proof of transfer. That's proof. The judges love that proof. And if you can't prove you sent something, it becomes a little bit more challenging. And here's why. If you can prove to the judge right now you sent it, he can issue an order right now. Versus, oh, well, I sent it regular mail and I got to now prove that they received it. And what if the receiver, or what if whoever received it is silent? What if they don't answer? How is the judge going to make a decision? Well, again, it's just easier if you can prove to the court right now and then that, hey, yeah, I can prove I served this.
Okay, you wanted to know about the different colors. You're going to see different colors in some of Dïevergent's paperwork. Let's see if you know what it means. What is the significance of using the following colors on court forms? A, black is for legal and public persons only. Blue is admiralty and represents the commercial world and everything to do with money. C, red is for urgency, correction, and the private. Purple is for royalty only. E, green is only used on military documents. F, A, B, C, and D. G, all of the above. Or H, none of the above. The colors make the forms eye-catching, but play no other significance at the end of the day. Brother Brendan, if you could please jump on the chat and assist Tejpal enter the class again, that would be lovely. Thank you. So what is the significance of the different colors? Okay, we got A, B, C, and D. So that would be number F. We've got a letter F. Okay, here's the correct answer. It's F. Very good. So here's some fun color facts. I'm going to let Darren speak to this.
We had a friend in the military that was telling us a story where he said, if you get a letter from the brass, as in the military officers, and your name is in red or green, he said, you better effing pay attention because it's important. Okay, great. I chose green to go, the trustees. Go, 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 go do your job. Is that legitimate? Is that bona fide? I don't know, but to me, it just kind of felt right. So black, the blue, blue to red, red to purple. This all kind of does have a little bit of significance. I'm going to suggest to do it rather than not do it. And if you don't have the rainbow of ink at your disposal, again, your paperwork's not going to fail if you all do it in black. It's okay. It's still going to get the job done. Recently, in X amount of years, we've started to see more ink colors being used from the government. They're starting to do it too. So again, it's just another layer or another code or another aspect that can convey information back and forth between the parties. And it is kind of neat, really, at the end of the day. At the end of the day, it's something to get your head wrapped around. Okay, so
here's our form notice of civil claim. Take 5 minutes. We'll be right back.
Sure.
Okay, let's introduce you to Form 1. This is a notice of civil claim, again, taken from the Supreme Court Civil Rules. Anything that we have put in red is what needs your attention. So it either has to be filled in or it requires you to be able to go and do a little bit of research. So let us explain. This is for the Supreme Court of British Columbia. You'll be able to find a Form 1 very similar in your area. This is in the matter of Sestuike Trusts, the Securities Transfer Act, and in the matter of the Trustee Act, and in the matter of the Personal Property Act. So again, remember how we mentioned you have to mention the acts that the following falls under. So we are primarily using, or we're actually only using these four. So who is it between? It's between you. So you have to style it as it appears on the bank or creditor statement, notice, or order. So make sure if it's in all caps, you put it in all caps. If it just has a first letter cap, do it that way. And who's the defendant? This is going to be the bank or the creditor that's going to be coming after you. Underneath notice of civil claim, it says Rule 22-3. This applies to all forms. This is something you're going to want to go and look out. There's certain color of paper, certain spacing you have to use. You need to leave room for the stamp for the court. This is information you're going to want to make sure you're not deficient in. Underneath it says name and address of person causing this writ to be issued. This is again where you're going to put the bank or the creditor's information as styled above and put their address below. So whenever you see the lines, please remove the lines and put their information in there, being mindful not to skew the alignment of the document too much. Now, this next section, this is just off of the form itself. This just lets the defendant know what's going to happen when he or she does receive this. This action has been started by the plaintiff for the relief set out in Part 2. If you intend to respond to this action, you or your lawyer must file a response or serve a copy of it on the plaintiff. If you intend to make a counterclaim, you or your lawyer must file a response or again serve a copy to the new parties. Judgment may be pronounced against you if you fail to file the response to civil claim within the time for response to civil claim described below. This will tell you the bank or the creditor, if they're inside of Canada, outside of Canada, or international, how long they have to actually respond. So if they're actually in your country, that's usually it's 21 days. If it's in the US, it's 35 days, and international, it's 45. Here's the claim, the statement of facts. So this is, again, the outline of how you fill out a Form 1. Using numbered paragraphs, set out a concise statement of the material facts giving rise to the plaintiff's claim. Well, here it is. To the sheriff, whereas it was ordered on or notice was provided on. Now, this is in red, but it's not italics. Italics means this is part of the form. You have to choose one of these two things to go in there. So you're either saying it was ordered on or notice was provided. It's going to be different. Then you're going to put in the date that you, the plaintiff, and then you're going to enter in the banking information recovered from the defendant. You're going to enter your name. Actually, that has to be reversed.
Okay, so
How did that happen?
the plaintiff, the bank creditor coming after you in the other case. Okay, but now you're coming as the plaintiff. So we literally have to switch these two around. So now you're going to be coming as the plaintiff and the bank's going to be the defendant. Remember back before we talked about, yeah, you do have some defenses from the defendant position, but they're not strong. They're not the best. You're better off. You're going to be in a better position if you also come as the plaintiff. Now the court is going to deal with plaintiff A and plaintiff B, and the court's going to decide who's got the greater priorities or the greater equities. So that's the whole point of doing this.
And whereas comes now defendant as plaintiff in a counterclaim. So this
Bingo.
is what it was. This is what it is now. The plaintiff, you're going to enter your trust information as styled above. Deliver to the defendant, you're going to enter your bank or your creditor name as styled above. Possession of financial asset or investment property, the collateral listing security by statement below in part and in order to satisfy outstanding obligations. So these next parts, these notices, these are kind of like a movie headliner. They're just going to say the main part and the rest of the information is explained further down in the legal basis. So here we go. On notice of writ of possession for interpleader relief on transfer and delivery up under disposition of interest attached to collateral. Notice of claim of beneficial ownership to property. Notice of writ of execution for seizure of interest in certificated security on return of security entitlement. And this is optional. Notice of class proceeding raising common issues filed at Supreme Court of British Columbia, file S227274, of which the defendant is a subclass member. So this is where you can choose to add yourself onto the paperwork or not. But either way, you're going to want to have these first three on there. And here's why. This is what the sheriff is going to receive. You are commanded promptly to take notice of and seize the collateral listed below for delivery up in part to, and this is where you'll put your banking information or the bank or creditor's information, under special endorsement and terms by the appropriate person to be entitled on acquisition of security entitlement under Section 95(1)(b) of the Securities Transfer Act to an equitable right or to relief arising on equitable grounds of disposition in part, assignment on condition of deposit of securities into court, made subject to notice of transfer and delivery up for the bank or the creditor to have rightful possession of it and discharge the matters at hand in full satisfaction of the amount owing, including any costs, fees, or expenses of execution, and for execution or executing this writ in virtue of the Trustee Act under warranties.
So you can see how that paragraph by itself almost gets the job done. But we're going to go into this a little bit deeper. And that in virtue of Section 36, persons who may apply for orders, and Section 3, receipts of trustees under the Trustee Act, respecting Section 48, seizure of interest in certificated security, the birth certificate, of the Securities Transfer Act, an order for the appointment of new trustees may be made on the application by any appropriate person beneficially interested in the equity of redemption of the mortgage, subject to the interest of the judgment debtor in the particular certificated security, birth certificate, being seized only by seizure of the sheriff. There you go. That literally said that the sheriff is going to take your birth certificate. He literally seized it. And the receipt in writing for the collateral in possession of the trustee, that's going to be them, or the sheriff at the moment, by reason or in exercise of any trust or powers reposed or vested in the trustee, is a sufficient discharge for settlement expressed to be received. And look at this one, effectually exonerates you, the person perfecting the collateral by delivery and transfer of the interest to the secured party for settlement, from seeing to its application or from being answerable from its loss or misapplication. Another loaded paragraph.
So if you're wondering how we do this, we take the two pieces of legislation, and by the way, all the legislation we're about to show you is everything we showed you at last class. We just took it and applied it and put it together so that it reads. This is the next part, and that subject to Rule 10-3, interpleader in accordance with Section 59, disposition of collateral of the Personal Property Security Act. After seizing the collateral, the certificated security, which is the investment property, the secured party, which is the sheriff, may dispose of it in whole or in part. Now, again, your endorsement is going to be saying in part. Now, after that happens, not less than 20 days before the disposition of the collateral, the secured party must give notice of disposition to A, the debtor or any other person who is known by the secured party to be an owner of the collateral.
Who's that? That's going to be the Crown. Who's the owner? Who's the legal owner of the birth certificate? Remember, it's not you. Continue.
B, any creditor or person with a security interest in the collateral. Number one, who is registered before the day that the notice of disposition is given to the debtor, a financing statement using the name of the debtor or according to the serial number of the collateral if the goods are defined in the regulations as serial numbered goods, or number 2, whose security interest is perfected by possession at the time the secured party seized or repossessed the collateral. And C, any other person with an interest in the collateral who has given notice to the secured party of the person's interest in the collateral before the day that notice of disposition is given to the debtor. And number 7, the notice of disposition referred to in section 6 that we just went over must contain the following information. So whenever they do an A, B, C, or D, this is all we do, is we just put that information in there. What is the description of the collateral? Well, it's investment property. You need to list collateral by statements. The legislation clearly identifies that, which is why we've set out the layout for you here. So on the left is the legal, and on the right is the new you. The new real you. So we've put Darren's information in here just to kind of help you see how to style it. You'll notice the difference on the left-hand side. For the legal name, you're going to be putting it exactly as appears on your birth certificate. You don't have to put it in all caps if your first name isn't in all caps. So make sure that lines up. But notice on the right-hand side, we use Darren's name, but only in first cap letters. So only the first letter is in capitals.
And you'll see how we got private entitlement holder here. Yeah, you could have security entitlement holder there. Instead of beneficiary, you could have beneficial owner there. We have a little bit of flexibility here. As long as we're in these lines, though, you're going to be safe.
B, the amount required to satisfy the obligation secured by the security interest attached to the collateral. So this is where you're going to want to enter the amount that's owing. And this is interest or any penalties. So it's the principal that's owing. C is the sum actually in arrears. So this would include the interest, the costs, or the penalties owing. The legislation says they want a brief description of any default other than non-payment. Well, you're going to either put non-applicable or any extenuating circumstances on why you couldn't pay. So maybe there was the vid lockdowns, maybe there was a death in your family, a disability or an injury, something along those lines. They also want the provision of the security agreement, the breach of which resulted in the default. So this is where you're going to attach the most recent notice of default from your bank or your creditor to Form 22. List of documents. If you're going to do this process, you need to be able to present to the court any documents of evidence. Form 22 is going to have to be done on your end as well.
And again, it's just a simple form. They're just asking you to list the documents that you're relying on for this proceeding. It's pretty straightforward.
Yep. And you can copy a lot of it from this form over to that one as far as the style of proceeding. D, the amount of the applicable expenses referred to in section 2A to seize, repossess, hold, possess, process, or prepare for disposition and disposing of the collateral, or to enforce the security agreement incurred by the secured party, and B, satisfy the obligations secured by the security interest of the party making the disposition, has not been determined, and the defendant is relying on Rule 10-3(9)G of the Supreme Court Civil Rules for the court to order all costs to be paid out of the investment property or proceeds. So again, this will depend if you're coming in as the defendant or the plaintiff. We set it up at the top so that you're the plaintiff, but if they're coming after you, you're going to be the defendant. So you're going to have to kind of change those words around in this form, just depending on your situation. And E, I agree through Setui Trust, the statement that on payments of the amounts due under paragraph B and D, any person entitled to receive the notice may realize the collateral on any private disposition or redemption of the collateral is to be made.
What does that mean real quick? If you give the security certificate back to the creditor, they realize on it. If you are taking the birth certificate of security and you're trying to do stuff with it for you, that's called redeeming it. So you got realize and redeem. They are similar, but they are different.
F, claim to security entitlements of property described as, and this is where you're going to put the VIN number to your vehicle, a credit card number, your mortgage certificate of title number, including any rents, proceeds, means profits, and accruals. Now, again, those rents and proceeds and means profits, you'll only be able to receive those entitlements once you have perfected your interest, which again, you can always go back and do, which is great. But at least this mortgage or any debt that you have is going to be charged. Here's part 2, relief sought. Using numbered paragraphs, set out the relief sought and indicate against which defendants that relief is sought. Relief may be sought in the alternative. So number 1, this is the first thing we're looking for. Subject to Rule 10-35, a sheriff may apply for interpleader relief. A sheriff who receives a notice of claim under Subrule 2 may apply for interpleader relief if A, the sheriff receives a notice under Subrule 3 disputing the claim, or B, the person who caused the writ of execution to issue fails to give the sheriff the notice required under Subrule 3 within the time required by that subrule. Number 2, subject to Rule 10-38, application for interpleader relief. An application for interpleader relief may be made without notice, and the court may deal with the application summarily or may give directions for service. So this is a play-by-play on what happens when the defendants either dispute it or they admit
Okay,
what
so,
it is.
and again, in this case, the defendant now is the bank. The bank is either going to admit your claim or deny it. As soon as they deny it, now the sheriff acts as interpleader and he files all this stuff in court, and he literally kind of sort of becomes your representative a little bit.
Number 3, subject to Rule 20-4, declaration of the rights of the parties. A, the consequent relief, advice, or direction sought relates to a question arising in the execution of the resulting trust and the performance of an act by the, and this is where again you'll enter the bank or the creditor name, and its agents in the person's capacity as trustee, and the determination of the plaintiffs entitled as creditors or otherwise beneficiaries to the trust property. And this is again where you're set out the address and, if available, the legal description of the land. B, the relief sought is for deposit of securities into court pursuant to Section 40 and distribution of estate under direction of court subject to Section 39 of the Trustee Act. C, the relief sought relates to land, and the action is for recovery of land and is for number 1, a declaration of a beneficial interest in or a charge on mortgage instrument number. This is where you're going to put your number in there.
And if you happen to have 2 or 3 numbers there, just comma, next number, comma, next, just list them all.
And of the character and extent of the interest or charge. Number 2, a declaration that settles the priority between interest or charges. Number 3, an order that cancels the deposited mortgage document of title or making the legal title subject to an equitable interest or charge. Or number 4, an order of partition. Here's the legal basis. This is what supports all that stuff. Number 1, subject to Rule 10-3, subsection 2, claim to real or personal property taken by sheriff of the Supreme Court Civil Rules. A person above who makes a claim to or in respect of property taken or intended to be taken by sheriff in the execution of any writ of execution or the proceeds from a disposition of the property must deliver to the sheriff written notice of the person's claim to the person's address.
That is this document.
This is where you're going to put your information in there. The debtor person information. Yes, that is yours, sorry. As it appears on the bank or creditor statement. So it's really important that how you style your name is how they have it styled on their end. So again, remove those lines and just put that information in. Number 3, sheriff to deliver notice on receipt of a notice of claim under Subrule 2.
Stop. Sheriff to deliver notice on receipt of a notice of civil claim under Subrule 2. Again, that's this document. This is the notice of civil claim under Subrule 2, and the sheriff is going to deliver this for you.
The sheriff must promptly deliver a copy of the notice to the person who caused the writ of execution to issue, and that person must, within 7 days after receiving the copy, deliver to the sheriff a written notice stating whether that person admits or disputes the claim. This is what we were talking about above. If the claim is admitted, okay, so the creditor, the bank gets this and they say, okay, not a problem. Promptly after receiving under Subrule 3, a notice admitting a claim, A, a sheriff must release any property, the claim to which is admitted, and B, the court may restrain the bringing of a proceeding against the sheriff for or in respect of having taken possession of the property. And unless the court otherwise orders, the person who admitted the claim is only liable to the sheriff for any costs, fees, and expenses incurred by the sheriff before receipt of the notice admitting the claim. Here's number 2. And furthermore, subject to Rule 10-3, subsection 9, powers of the court on hearing application of the Supreme Court Civil Rules, and section 63, supervisory jurisdiction of court of the Personal Property Security Act, on the hearing of an application for interpleader relief or of a debtor, a secured party, a sheriff, or a person with an interest in the collateral, the court may make one or more of the following orders. A, an order including a binding declaration of right and injunctive relief that is necessary to ensure compliance with this part or section 17. We tack that on. Rights and obligations of secured parties in possession of collateral of the act. The secured party must use reasonable care in the custody and preservation of collateral in the possession of the secured party, including taking any necessary steps to preserve rights against other persons.
Again, this security, this financial asset in the possession of the sheriff, this is an incredibly valuable instrument at this point. That's why these sheriffs carry guns for instances just like this. That instrument he's carrying around is worth a lot more than his wallet full of cash, even though this thing doesn't have cash value. Kind of strange, but there you go.
B, an order giving directions to a person with respect to the exercise of the person's right or the discharge of the person's obligations under this part or section 17. C, an order staying enforcement of rights provided in this part or section 17.
That's the court stopping the bank's foreclosure proceeding. It just got stopped.
D, an order necessary to ensure protection of the interest of any person in the collateral. E, on the request of the applicant or property claimant, determine the rights of the property claimants similarly.
There's the declaration of the rights.
F, stay any further step in proceeding file number. That's where you're going to put any other chart or file case numbers. G, order the costs of the applicant or costs referred to in section 59.2 of the Personal Property Security Act and Rule 10-3, section 7, subsection D of the Supreme Court Civil Rules to be paid out of the investment property or proceeds.
Okay, Darren, why are we dealing with the Personal Property Security Act if we're actually dealing with a house, which is real property? Shouldn't we be using the Real Property Act? Yeah, but we're dealing with a certificate at the moment. The certificate falls under the Personal Property Security Act, not the Real Property Act.
You guys are going to like H, declare that the liability of the applicant, which is you, with respect to the property, is extinguished.
When your liability is extinguished,
that's a win. I, declare security entitlements to property described as, this is where you'll put in any of those applicable numbers, including any rents, proceeds, means, profits, and accruals. And J, make any other order the court considers will further the object of these Supreme Court civil rules. And this is optional for those who get into this sticky situation. You go, okay, I'm over my head. I need divergence to help me out here. And that for the direct purposes of avoiding a multiplicity of suits and wasting court time. Notice is being provided to the defendant joining or requesting to join a multi-jurisdictional class proceeding as a subclass member for common issues raised, currently filed in the Supreme Court of British Columbia, file number S227274, pending approval and deposit of security into court in whole. That's going to be a big wow for the court to see, because when you are depositing it in part, but you have intentions to deposit it in whole over here, and the judge has the ability to go and look up the paperwork that we have filed in the background, that's going to be a big win for you, or at least enough for them to be able to go, we need to back off. Pursuant to section 4, subsection 1D and section 2, Class Certification of the Class Proceedings Act, if a court has determined a class proceeding would be the preferable procedure for the fair and efficient resolution of A, claims of the subclass members raising common issues, whether or not those common issues predominate over issues affecting only individual members, and B, other subclass members claiming that are or have been subject of any other proceedings in accordance with section 11, stages of class proceedings, and section 27, determination of individual issues of the Act. The court may give judgment in respect of the common issues and separate judgments in respect of any other issue, and in doing so may provide any necessary directions relating to the procedures that must be followed in conducting hearings, inquiries, and determinations under Section 1 and 3, or authorize any special procedural steps, including steps relating to discovery or special rules relating to administration of evidence and means of proof that it considers appropriate.
Okay, so what does that really mean? Well, again, if you're in Australia and you're trying to deal with a part interest there, but yet you're trying to deal with the whole interest over here in British Columbia, you literally tell the judge in Australia, hey, Your Honor, how would you like me to proceed? What do you want me to do? Do you want me to deal with it in part here? Or should we let the court in British Columbia deal with the whole, and then the court in Australia will know how to proceed? And we literally had a loved one about 6 months ago do this in a foreclosure proceeding for a mortgage. And the judge in Australia said, let's just hold on and let's just wait and see what happens in British Columbia. So that's that judge respecting what we're doing in British Columbia, trying to deal with the whole problem.
Okay, so here's the bottom of the form. This is where the plaintiff's address for service, put the address in there, fax numbers, emails, the place of trial, so you can actually choose which courthouse you want to go into, and just make sure that you enter the address as well. Again, a sign or in blue. This is a situation where you would want to align the paperwork here, because you don't want to ever be signing on a page where that's all that's there. You want to kind of bump it down so that it flows a little bit better, like having your signature up here and then your typed name down here. You'd want to just space it out so that there was a little bit more on this page.
Because what would happen if the last page here went missing? Oh, now we got no signature for the rest of this entire document. So you see, it is sort of a little bit of tic-tac-toe. I know we get a lot of questions regarding, yeah, but I'm going to be doing equity and I'm not going to be signing. I'm not the signature. I'm not any of that sign stuff. That's all legal, blah, 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 blah. I'm only going to do autographs. Point being, you're the sinner judgment debtor. So go ahead and sign for now. Once you get a court order saying that, oh, John Smith, yeah, you're entitled to the securities. Yeah, you're the beneficial owner. Okay, now autograph everything after that fact. But before the judge is giving you the order, granting you that power, or suggesting, yeah, Darren, you're the security entitlement holder, just sign, don't argue, because as soon as you start arguing or presenting anything that's confusing, the judges get pissed off in the court. They'll literally look for a chance to bounce your stuff.
So for these reasons, we're going to move into our AAA now. So what we just finished up was for members who do not want to join our class proceeding. So you are welcome to stop the recording here, because anything from this point forward, you won't want to hear anyways. For those who are sitting on the fence, for those who've already joined, it's wonderful to have you. And for those who this is brand new to you, this form is going to help you see Divergent's intent, the movement, our initiative, what we're trying to do. And when you look at costs in the Class Proceedings Act, it talks about how the court can make decisions on any entitlements or payments that are given out, as far as making sure that your conduct is appropriate, that you're not being vexatious. And this is why we have spent a lot more time going over this form to ensure that we have plugged all the holes, that there is really nothing that anyone could come at us with, specifically the court, because we're not too worried about persons. We're worried more about the court and making sure that they see our workable plan to be able to advance the class proceeding, because that's part of Darren's job. If we don't have a way of moving you guys through this and of being able to show an acceleration of knowledge and of this going somewhere, they won't approve it. So this will take care of that. So thank you to the subclass members that fared with us last week when we were making those changes, because as subclass members were joining, they were bringing up situations where we're like, oh, we got to talk to that. We got to put, that's an entrance requirement. And we know some of them might disturb you a little bit. And that's usually for the ones who will not be accepted. And we do have reasons for that. We're going to go over it. It doesn't mean that we've forgotten about you, but for right now, as far as first and second waves going through, we have to make sure that past decisions that you made are not going to affect the class proceeding moving forward.
So in a nutshell, this administrative agreement that you're looking at, this is actually getting sent to the court. This is part of our plan.
It's in our list of documents. So I'll get you actually to read the header. So this header is in every page that we have, and there's a reason for that. So
Okay, so to all to whom though these presents shall come, take actual notice. Again, actual is important here. That by declaration of the appointer, that's you, concerning the underlying securities, that's the birth certificate, in direct appointment of new trustees, that's the new ones coming in, pursuant to section 27 of the Trustee Act, as relates to the trust property vested in those persons, thereby to act in good faith according to the act and the civil rules.
So what we've done to make this really easy is you see these little quotation boxes. Now there's one that's right beside date, but on the far right of the form, we've inserted these on any certain areas that may require a little bit more detail. One of those being, how do you include the date? Well, there you go. It's always day, month, year in court form. So please do not rearrange that. The Ascending Administrative Agreement is our form AAA, we reference as the AAA, annexed in evidence under SCBC file number S227274 in virtue of section 17, subsection 2 of the Class Proceedings Act, discovery on representative plaintiff's motion for leave of court to discover other subclass members.
I actually have to apply to court for leave so that I can go and find you and then add you to this. I actually have to make that application first, though.
So here it is. So let's move through this. Attention, subclass member and or Madam or Mr. Justice. The special intent and purpose of providing this notice is to discover other possible claimants whom share identical or common interest inherent to those of class members in proceeding file S227274, commenced at the Supreme Court of British Columbia in Vancouver, Canada, subject to class representative approval for deposit of security into court. So just so you know, how we're setting our paperwork up is Darren and I are the class 1. And after that, there are subclasses after us. So in that situation, Darren is going to be the class representative for us both. However, we are appointing a minister to be able to be the subclass representative for all of you.
And it's not quite a minister, but she actually used to be the Deputy Attorney General of British Columbia. And since she's been promoted to the Deputy Premier of the province. So she's a big gun. She was the former Attorney General, the one with all the knowledge. So this would be a fantastic lady to have as the representative class, subclass plaintiff to help everybody else out, because she knows stuff that even I don't. And that's going to be a power move that helps to streamline everything moving forward.
So you're going to be, any subclass members are going to be dealing with her and any of her people. So you notice on the right-hand side, there's one of those little boxes and it applies to where you're going to put your name after notice. So this is where we're going to ask you to remove the line and insert your name exactly as it appears on your birth certificate. So you'll put your name and it'll state that you wish to opt in as a subclass member, seeking either common or similar equitable reliefs sought under the multi-jurisdictional class proceeding file at the Vancouver Registry, with the option to participate in Dïevergent's Trusted Life Training Program, where I agree to enter into an agreement of ascension to perfect my knowledge of equity and its doctrines through various classes, ascension missions, and quizzes, recorded relating to my real life overcomings. This is what's known as your record of involvement. My final rise to perfection and equity being evidenced by way of Dïevergent's entitlement competency test, whereby I may or may not exhibit having acquired the necessary skills to file, present, and speak to the class proceedings, cause of action as individual, relief sought in proper execution of my entitlement holder rights to issue the appropriate instructions, directions, and orders for a final determination to be brought before a judge in equity respecting my overall knowledge of the perfection process and ability to direct, manage, and handle my own life affairs.
Okay, so what does that mean real quick? That means we're opening the door, we're getting the process started, and it's waiting for you. When you are finally ready, you literally take over, you make application to the same judge, and say, hey, Mr. Thompson, I think I'm ready to pursue my individual claims. I believe I'm at a point now where I don't need Divergence and Darren and Jody or anybody else. I think I can do this on my own. You literally make your own application to the judge. And if it's approved, boom, you're going to be teaching classes just like this.
So this is what's wonderful about it, is Divergence will perfect your interests, but in essence, we're putting an equitable lien on your life estate. And that lien is us showing the courts that we're giving you access to your life estate, but not unrestricted access until you have the ability to perfect your interests on your own. We feel that is very fair, because for someone to come in and say, you guys don't have that right, well, how are you going to handle your affairs if we let you in? You need to be able to, again, like it says, appropriate instructions, directions, and orders, because it works very different in equity than it does in the legal world. So this is what's great. We're not trying to do anything but make sure that the court knows that anyone coming up the ranks, the cream that's raising to the top here, are going to be competent. They're going to have the knowledge and information to be able to speak to this.
At the end of the day, I want all of you / up-and-comers to be at a place that's higher and more ascended than I am, than we are. Motivate, encourage, go, go, go.
Should my record of involvement and competency results affirm eligibility to bring forward my own individual claim for final determination respecting unrestricted access to my life estate with no cause of concern as to the possible misuse or waste of court time. Subject to Section 27 of the Class Proceedings Act, a judge in equity will make a determination as to my level of competency to handle my whole life affairs and on my own accord, absent any oversight or protection from Dïevergence Foundation Trust, and make any orders it deems appropriate, including deny my individual claim to unrestricted access to my life estate, but grant additional DSERA and Crown credit entitlements, or issue time-sensitive conditions on when I may reapply to court. So if you completely drop the ball in the court, the judge might say, you know what, you got to go back, do some more training. You can't reapply for another 6 months. And here's what's great. Once you pass Dïevergence competency tests so that you can apply to court and do this on your own, you got to get past the registrar first. You don't even get to see a judge before all of your paperwork is dialed. It's filed for the judge to see. So you can see how you need to be able to, the forms, learning that is such a crucial part of this. Now notice, until the court otherwise advises, or your subclass representative or administrator, individuals requesting to join the class proceeding and receive DSERA and Crown credit entitlements must return all of the following to Dïevergence@gmail.com for subclass member approval and their record of involvement. So as long as we're working with the paperwork, we are pre-approving that. However, eventually that's going to be Shannon Salter, if she gets nominated as or appointed as the trustee, she's going to be approving all of this. And that's what's great. Darren and I don't want to be doing this. We want to lay the path out, give you guys the instructions on how to do it, and then the trustees roll in and they're the gatekeepers. Form AAA, which is a AAA, has 19 entrance requirement questions you're going to have to answer. You're also going to have to attach a video. We need to know who's behind the form. So you're going to have to speak to all of your answers. You're going to have to attach a copy of your birth certificate to the form, which we're going to show you where you have a place to do that, and fill out Form 70, which is a notice of interest to attach your interest to ours. And
just to, as a bit of a heads up, when you're doing your video presentation to us, for a presentation to the court, that in itself is almost a test. It's bringing you to a level where you need to be somewhat coherent when you're speaking. You need to be able to speak effectively. You need to be a little bit excited. You need to be able to show the judge that you're truly interested in what's going on here. Put some passion, put some love, put some character into your video, because again, the judges are going to be looking at this and they are keeping track of everything.
Here's what it looks like. So you're going to mark any answers to the 19 entrance requirement questions in the yes, no, or not applicable column and insert any letter answers that apply to you. If you would prefer to highlight the answers that are applicable, that is also permitted. So you're going to start your acceptance video here and you're going to say I, you're going to spell your name after you say it exactly as appears on your birth certificate. In accordance with Section 19 of Certification of the Class Proceedings Act, agree to provide the following information to the trustee, class, or subclass representative as required for any necessary court communications and/or notifications. Remember, once the class gets certified, any subclass members are going to receive notice of everything that's going on, including any claims that they have attached and the relief sought that you are asking for. So we're going to ask that you please remove the lines, insert your mailing address, your email address. Please be mindful not to change the layout of the document. It is so important. Everything is positioned perfectly. If you bump it down one, everything moves down and it's going to get screwed. So we want to make sure that you just watch that if you can. So here's question number 1. Have you received this? Yes or no? Now, when you're answering this, you don't have to read the bottom part if your answer is no, okay? But if yes, are you aware that persons who've received that are up against property rights claimed by the US government under patent, which is an additional layer that Dïevergent has chosen to not entertain at this time?
But in the probably not too far future, that will be on my list for things to do today. So
we just have to do some research first, loved ones. We need to make sure that that decision did not give your rights away to somebody else. We can't claim something that isn't yours. So it's important that we find out what happened in the background first. So please enter your answer in there. Question number 2 is, do you smoke cigarettes or vape? This is not speaking to marijuana. This is speaking to the Satan sticks, as we like to call them. Yes or no? Again, if your answer is no, you do not have to read the yes information below. But if you do, are you prepared to permanently quit by the time you endorse this instrument?
And again, this is important to us. Smoking may be important to you, but at the end of the day, we're trying to come with clean hands, clean mind, clean spirit, clean, clean, clean. And if we think that we're bringing some of these other masters with us and we're going to get into equity, we're just suggesting, hey, let's all try to overcome as many situations, addictions as we can, just to cement our initiative moving forward.
And that's why if yes, and after 90 days, we are asking these members if they are open to providing the court any necessary testing to validate this overcoming. So very much like life insurance, you have to do some forms of testing. We don't know what the court may ask for, but we're leaving that open where if, for instance, something like blood work is required, that you're open to that. As much as this is a trust agreement for you to trust us, it's also for us to trust you. And we need to know that you're willing to be able to provide that proof so that we know that trust is in place. Number 3, this also relates to pharmaceutical medications. So again, this is if your doctor is writing prescriptions for pills. And if you are taking them, if you're prepared to consider immediate holistic alternatives. So for those who are very programmed and of the belief that you need to take your high blood pressure, your diabetes, your insulin, these kinds of things, soon other remedies and healing modalities are going to be open, and we need to know if you are open to that as well. And that's why, again, after 90 days, we want to know if you would be open to receiving any necessary testing to validate to the court that you have overcome this.
And again, that testing could just be, have you overcome? Did you quit? Do you still consume? No, no, no. Well, that could be all that the test is.
And with all the numbers out there, anything that's written for a prescription is documented on the World Web. So they'll be easily able to go and verify that if you're still getting prescriptions. Okay, so question number 4, this was actually just put up as a quiz question on our Telegram channel. This was one we had to add last minute, but very relevant. Have I sworn an oath to His Majesty for a position in public office, such as a lawyer, a police officer, or a government employee? So again, if you haven't, just say no, move on to question number 5. But if yes, are you aware that your inheritance is different and you're not eligible to perfect your interests or access your life estate on oaths to other masters, such as the crown, and they are contrary to equity and James 5, verse 14. So why is this? Well, it's largely because these individuals have access to privy information, and they can use that to enrich themselves. Here's another reason. We mentioned scripture, and there's a very good reason for that as well. James 5, this is from the King James Version. On the right is the American Standard Version. They're very similar, but there's a couple little word differences that they have. Verse 11 says, behold, we count them happy who endure. On the right, it says, behold, we call them blessed that endure. Ye have heard of the patience of Job and have seen the end of the Lord, how the Lord is full of pity and of tender mercy. But verse 12 says, but above all things, it's not, hey, this is important, make sure you listen. Above all things, number one, my brethren, swear not, neither by heaven, neither by earth, nor by any other oath. Let your yea be yea and your nay be nay, lest ye fall into condemnation. On the right, it says that ye fall not under judgment. Now, I don't know if you've ever looked these words up. Sometimes judgment, we think that's just our ability to reason or make a decision. Not true. Well, that is true, but it depends if you're looking at it from the synonym or the antonym version. In Oxford, the definition of condemnation is the expression of very strong disapproval, the action of condemning someone to a punishment or sentencing. When we look at dictionary.com, it's the act of condemning, the state of being condemned. Notice when number 5 says this was a shocker for us. In the US law, the seizure as a property for public use.
So when you've been condemned, you've literally waived and forfeited all things equity, and now you're
things Caesar.
And now you're just for public use. The public is literally using you.
So that's pretty much when the crown has you hog-tied. And when he's got you hog-tied, there's not too much, there isn't anything that we can do. Look at what Oxford means of judgment: a misfortune or calamity viewed as a divine punishment. It's retribution, it's a penalty. So this is why we're gonna have to, sadly, not be able to accept applications for individuals who have taken an oath. These are mostly people who are working in office, the firefighters, police officers, these kinds of things. Number 5, I shall uphold the maxims in my daily life, specifically an exercise of the spirit of equity. I promise to be vigilant as equity demands of me. I further acknowledge those who seek equity must do equity. Now, we're going to encourage you to focus on the 12 tables of equity, which is taken again from the Suits and Chancery. These are the primos. This is what a court of equity is going to be primarily looking at. And look at some of them. Equity will not suffer wrong without a remedy. It imputes an intention to fulfill an obligation. It regards that as done, which ought to be done. It regards the beneficiary as the real owner.
Remember the mortgage document? Remember the beneficial owner, whether or not he or she is named in this agreement, which you were. Well, there you go.
Okay, so we'll let you read those ones over later. Here's question number 6, my reason for joining the class proceeding. And we're going to ask that you speak to any answers that resonate or anything that's not mentioned. So if you're like A, C, D, and E, make sure you speak to all of those and include them or highlight them. So A, you have joined the class proceeding because you want to become an equity master and help teach this wisdom to the world. B, you want to dedicate your life to being an ambassador of equity and appropriate funding where necessary for those so entitled or in need. C, you want to become a spiritual master and help heal the world. D, you resonate with the overall vision and workable methods of the proceeding. E, having contemplated your fraud, error, accident, mistake in good faith and good conscience, you could no longer identify and remain in adverse possession of the person. Or F, I only joined to receive the Desera and Crown credit. So either, whatever your answer is, like we said, if you just want to come in and deposit your security interest and take your Crown credit and go into the mountains and enjoy your life, so be it. But we want to know and get a feel for the individuals that are coming in so we can best decide how we can help you. Number 7, I agree to attach a copy of the security certificate, the birth certificate, in whole for deposit into court, subject to original terms referred to below in the style of proceeding. I went and grabbed that and dropped that in so that you know exactly what those original terms are.
Which is just a repeat from what we said earlier in the show, but do it again.
I thought this one was a little bit different. Yeah.
By the appropriate person's moral claim. If you're a moral claimant, that means you're not doing legal. To be entitled on acquisition of security entitlement under section 95(1)(b) of the Securities Transfer Act to an equitable estate or right, or to relief arising on an equitable ground of disposition of interest under absolute assignment. Again, there's two types of assignments. There's assignments and then there's absolute assignments, two different things.
An assignment in part, which is what we were talking about, or an absolute assignment. This is where the endorsements are different.
On condition of the deposit made subject to notice of transfer by delivery to or into the name of the district registrar in file number S227274, taken on account of investment property by the Minister of Finance, is actually who it is, at Treasury, subject to Rule 23(4). Now, again, when I mentioned earlier in the class, go see 23-4 subsection 9. Dynamite. In virtue of the Trustee Act and the Crown Proceedings Act, all under warranties.
So this is why we removed the option for you to send your birth certificate directly to the courthouse. It's all now streaming through the trustees and then it gets deposited into court. So this avoids, like, if you made a deficiency on your endorsement or something along those lines, it's got to get sent back to you. This is going to avoid any back and forth. Okay, so here's number 8. I agree to assign the whole equitable estate to Dïevergent Foundation Trust under terms of administration, disposition of interest and assignment until further orders. Let the record now show, subject to section 39, distribution of estate under direction of court, and section 37, costs. I am entitled as beneficiary to the following amounts of DSERA and Crown Credit entitlements from my life estate. And we're going to ask that you don't just say number 1 and move on. You say, for instance, if you're over 21, I am entitled to the subclass member. Over 21, my restricted DSERA is $125,000 a year, credited monthly. My restricted Crown Credit is $2 million per year. Now you're going to notice we have different sections here for subclass members between 14 and 21. And we will accept subclass members as young as 7. Now, why 7, 14, and 21?
Okay, so when you're born, if no action is taken up to 7 years, it's deemed abandoned and now the state steps in. So you can literally be 7 years old and you can start this process. In increments of 7 years, again, the Jubilee happens every 7 years. So 7 years, 14 years, 21 years, these are all significant timelines in your life where you could have been doing things had we known. You know how a lot of religious groups out there, I think it's the Catholic faith, they do something called a confirmation. When you are confirmed to the faith, or however they phrase it, when you're around 14 years old, you know what that was supposed to be? That was supposed to be the 14-year-old confirming equitable doctrines and principles and disposing of a security interest or a legal estate that was attached to them at birth, not just standing up in front of the congregation and saying some hallelujahs. That's not what the confirmation was supposed to be. But through the churches, how they do things, things got a little bit sideways.
So what's beautiful about this is if there's little boys and little girls around the world who are in homes that are being hurt, in homes that are not of a healthy nature, they can make application and they can get themselves in a position or to a place where they are safe. And that's what we're excited about. We have also included members with severe disabilities, special needs, or are disadvantaged. And we'll talk about that in number 17 coming up.
I don't know if we talked about this later, but these little amounts that we attached just previously, these are the starting numbers that we figured out. Okay, if you can get paid $125,000 a year or $250,000 a year, that should be enough for you to quit your job so that you can focus only doing this stuff until you're ready to take the power from Dïevergence for yourself, and then you're off to the races. So we're trying to do nothing but encourage people. If it turns out you need more than $250,000 to live, then you just make application to us or send us a notice or some type of
Tell Shannon, the trustee, the advisor.
And all that can be dealt with. So again, a lot of people are going, oh, who the hell do they think they are saying that I'm only going to get $125,000 a year when I'm right now making $1.25 million? fine. We're just trying to put you in a position where you have no distractions so that you can focus your life on this stuff.
So number 9, your self-assessment of your current knowledge of equity. It's either going to be beginner, intermediate, or experienced. If you're experienced, you can also ask to take the Dïevergent Fast Track competency test so that you can see if you fall into any of those categories, and we can, again, direct you to the appropriate training course. Number 10, my available training hours per week for Dïevergent's Trusted Life Training Program with the applicable DESERA and Crown Credit entitlements. We know when we ask people how many hours could you dedicate to learning about equity right now, we know usually that number is quite small. However, once you're starting to receive this DESERA, we want to know how many hours you would then have available to dedicate. And we want you to please explain any limitations on your availability as well. That's why question number 11 is very appropriate for the next question. My preferred way of learning is I want to perfect my interests and handle my own life estate affairs full time, and will make the Dïevergent's Trusted Life Training Program a top priority in my life. Or B, I prefer to learn how to perfect my interests and handle my own life estate affairs part-time and at my own accord. Or C, I do not want to learn how to perfect my own interests at this time and prefer Dïevergent's Foundation Trust handle my life estate affairs and entitlements. So what we're trying to establish is how many people, if we said we're throwing a 90-day course, drop everything, come, we're going to teach you as much as we possibly can in these next 90 days, how many people could do that? Or how many people would be best suited if we had a cruise ship, for instance, and you came for 3 days or 5 days or a week, and you came and immersed yourself free of distractions, no children, no animals, no spouses. Or if you come with your spouse or your partner, you stay in separate rooms. Darren and I have talked about this already, so that you have the ability to be removed from distractions, have the solidarity to be able to focus on this. So what is that? Are you a mother with young children and you can only do 10 hours a week? Or are you someone who's free and single and has no obligations and can say, where do you want me, Dïevergents? I'm coming. Okay, so that's what we're trying to establish. Let's move into question number 12. Upon entry of the Trusted Life Training Program, I agree to take Dïevergent's competency assessment test to ascertain which course and at what pace I would be best suited, having regard to my current level of knowledge respecting the perfection process and ability to handle my own equitable life estate. You have to get, though, loved ones, 90% or higher on the competency assessment test as soon as you enter in, and the fast track competency test to qualify for the fast track option. So there's 2 tests you'd have to take that you have to get 90% or higher in order for us to fast track you. When we say fast track, the reason we need 90% is because then there's just a little bit of polishing and you're good to go to court and do this on your own. Number 13, I agree to the record of involvement demonstrating my participation and test results within Dïevergent's Trusted Life Training Program, upon which and based on those achievements, I may become eligible for the subclass administrator, this is Shannon, to apply to the court for an order to distribute additional DESERA and Crown Credit entitlements in accordance with Section 39, distribution of estate under direction of court, and Section 37, costs of the class proceeding.
This is going to become effective and important at some point because the class has subclasses that are deemed resident and non-resident. So anything outside of British Columbia is going to be deemed non-resident. So for every man or woman in every province, territory, or state out there in the world, they have the ability to actually be a representative plaintiff for their entire state or province. And the court is going to deal with that individual who's managing, they could have, I don't know, 150 people below them. We're trying to get people to get to a level where they could be these class representative plaintiffs. The court could appoint someone who's not involved in the class proceeding, or they can choose a class or subclass member. So there again, it's more incentive to just always be doing better and better and better.
So this was reviewed in the beginning of the form, but this is where you actually have to speak to it. Upon completion of Dïevergent's Trusted Life Training Program and passing Dïevergent's entitlement competency test, I may, or may not make an application to the court for a determination by a judge in equity, respecting my ability to file the necessary individual paperwork to properly present and speak to the perfection process as a whole, to include exercise my entitlement holder rights, to show I have acquired the wisdom to manage my own equitable life affairs, absent any oversight or protection from Dïevergent Foundation Trust. So that's going to be the key. You can't need divergence anymore. There can't be, okay, I just have a couple more questions, or if you can just tell me what to do on this, that means you need more training. Number 15, this is for the subclass members who have active court cases. You can speak to the one that you're involved in and then briefly describe the claim being asserted by or against you and any time-sensitive dates that we have to be aware of. So again, when this is going to Shannon, and you have a court case coming up in 2 weeks, she's going to need to know about that so she can get her people in place for you. Then you're going to want to speak to and joining this case to the class proceeding for the relief paid for in the common issues raised in action file number that's here in exercise of my subclass member entitlements referred to in section 19(6)(f), notice of certification of the Class Proceedings Act. Number 16, I understand that any judgments made on common issues of the class proceeding binds every member and the subclass who does not opt out of the class proceeding within the time specified in the certification order in accordance with section 26 judgment and section 16 opting out of the Crown Proceedings Act. Loved ones, we're going to really encourage you to go and look up this legislation that we've quoted, especially if you're a subclass member. This will be one of your first ascension missions that you're going to be doing, is breaking this all down, preparing you for court. So if you were asked, what does this pertain to? You can speak to it. So make sure you go do your due diligence on that. We've only got a couple more here. Number 17, I'd like to make application for an individual with severe disabilities, special needs, or disadvantaged. So we threw in disadvantaged because you might know of someone who has just gotten the short end of the stick, just has situations or circumstances that are very extenuating, and you'd like to make application for them. You can actually attach a copy of their security certificate in whole for deposit into court and assign the whole equitable estate to Dïevergent Foundation Trust under terms of administration, disposition of interest and assignment until further orders for the granting of any appropriate DSERA and Crown credit entitlements deemed fit to ensure his or her ongoing medical care and overall well-being are met. So this is what's great. We're not going to put a cap on that. We're going to let the court decide so that when the individual who's bringing this forward, who's speaking to the relationship and the background of this individual, they can assess what would be appropriate.
And again, this is important because remember, loved ones, we're outside of the scope of insurance, medical insurance. We don't use that anymore. So if you have a child or you have a loved one that has a child that is disadvantaged or is challenged and requires all this additional medical care, I know, like in the United States, for example, some of these medical treatments are ridiculously expensive. So let's say you qualified for $125,000 a year. Yeah, but my daughter's medical treatment costs $65,000 a year. See, you would need extra funding. So again, we're just trying to provide for all the what could happens.
And you would just make application for that in your acceptance video. Number 18, I am unable or I do not wish to enter Dïevergent's Trusted Life Training Program because you would explain why. However, I wish to be a subclass member and deposit my security interest into court under terms of administration, disposition of interest and assignment until further orders to help fund Dïevergent's Foundation Trust and receive DSERA and Crown credit entitlements, which may include bringing forward an application in support of any charitable works or world initiatives that are near and dear to my heart. I also understand I'm free to join Dïevergent's Trusted Life Training Program at any time to increase my knowledge of this process and receive additional DSERA or Crown credit entitlements. So this isn't just limited to individuals who are depositing their security interest who don't want to take the training program. Anyone, subclass members who do have some charitable works or world initiatives can also do that as well. But we wanted to kind of put in those little extra features. just for individuals who might not be able to do the course. Now, at the very bottom of the AAA, you're going to notice this section here in the middle. There's some bubbles around here because there's a lot that you need to know. At the very top, we're going to ask you to sign using a blue pen or insert a box or a new signature box and sign using the cursor. So if you print this off, use a blue pen, or else you can insert the box and use your cursor to do a little squiggly. Underneath, it says to print your name in blue using first caps. So we've put an example on the far left to style it. You can see how Darren, Murray, Murphy, Clifford, it's only the first cap that is in all cap. Below, we have the option for you to put your red thumbprint if you wish. If you do not wish to do that, you can just remove that box and not put it in. We're going to ask for your address to be put underneath subclass member 1. Remove those lines, insert your mailing address, and again, being mindful of the layout because the notice of civil claim is directly underneath this. And then again, put the date, which is always day, month, year. Okay, so here's the next portion of it. This is what's going to be given to Shannon, the amended notice of civil claim and your request to join as a subclass member in trust. We've already gone over the original terms. There's Shannon Salter listed as the trustee. Again, the one that you guys are going to be dealing with. Here's a section for inserting the front image of your birth certificate. Please shrink it if necessary. It's important that that does stay in the box, and the back side as well. We need to see that for any serial numbers. All those serial numbers mean something different. I noticed actually in Australia, you guys have sometimes 2 or 3 of them, which is very interesting. Okay, that's it, loved ones. That's all you have to do for the AAA. That is going to be available on our Telegram channel. I'm going to tell you about that in just a moment.
I just want to talk quickly here up at the top of this form where we had the bank information.
There's no banking information.
Okay, where we had a box where it said is it the defendant or plaintiff's address? And we had, who is the party executing this writ? And we want our address there, not the bank's. Yep, go back, find it. Keep going.
Okay, hang tight here, guys. Oh, it's on the form, that's why.
Yeah. Because here's the deal, there's 2 writs going on. Remember, the bank coming after you, they issued a writ of execution. Okay, that's them being the plaintiff. Now you're stepping up as the plaintiff. You are also executing a writ of execution. This form is on your behalf, and we want your address to be there, is what we have. And I'm suggesting that we want the, no, top.
This is form 70, sorry. It's not what I want. Oh my. Okay, you're gonna have to give me a minute, honey.
Okay, yeah, so we'll go back and touch on that one later, but again, it was at the top of the form where it was, you know, the brackets with the X, plaintiff, at their address, and the defendant, at their address. I'm saying that I think we had that reversed. We're just gonna have to double check that one, but.
Okay, I'm having just some errors come up, so I can't. Okay, well, you can add a little extra video on that later on,
Sure.
okay? Okay, give me a second here.
And to wrap today up, we're not going to do any questions on this episode because I know that we've already gone like almost 3 hours here. So
no, we still have more, honey. We still have form 70 here to go over
at the end of the class. So we're going to ask that all questions, jot them down in the chat, and we will dedicate next Saturday to pretty much just a question and answer episode without all this other paperwork. And here's why. it kind of gets to a point where when we lay out so much information, we're kind of defeating the whole purpose of having a class proceeding. We're literally teaching everyone just to go off and go on their own and do it. But that's going to take time for you to go and do. So we're saying, no, just join the class proceeding first, and then at your pace, you develop the ability now to go and, manage your own affairs.
Form 70 is easy peasy, loved ones. You can look this over. The style of proceeding is exactly the same. All you have to do is you're going to have to see, as you can see at the top, take notice that I have an interest in this proceeding. You're going to remove those dots, put your name in there. You're going to put your address for service, your email address. It says here, for the purpose of section 19 and 63 of the Securities Transfer Act, subject to transfer and completion of security certificate. Number 1, notice of transfer. It says section 19, having knowledge that a financial asset or an interest in a financial asset is being or has been transferred by a representative does not impose any duty or inquiry into the rightfulness of the transaction and is not notice of an adverse claim. Do you want to explain what that is?
Yeah, this is sort of important. What it's saying is what you just wrote on the birth certificate and or the other document to go with it is rightful, and the judge doesn't need to do an inquiry. The judge doesn't need to do an investigation. We're saying that we're doing this bona fide, we're doing this with honor, and we're literally trying to save the court a step at this point.
If a security certificate contains the signatures necessary to the securities issue or transfer, but is incomplete in any other respect, any person may complete the security certificate by filling in the blanks in accordance with the person's provided authority. And B, even if any of the blanks are incorrectly filled in, the security certificate as completed is enforceable by a purchaser who took the security certificate for value and without notice of the incorrectness. Number 2, a complete security certificate has been improperly a complete security certificate that has been improperly altered, even if fraudulently, remains enforceable, but only according to its original terms.
So again, the original terms was this particular paragraph. That's locked in stone. Once that's on the other document or written on the birth certificate, that's all it takes. But again, this isn't our words. This is out of the legislation and the court rules. This is saying that even if Dïevergent did this all completely wrong, even if they did it fraudulently, the court can still deposit your birth certificate and credit your securities account. So it's kind of like, no matter what we do, we can't screw it up. Wow, well, that's kind of good news.
Number 2, subject to the SCCR rule 23-4. We've been talking about this one a lot. Look at all those numbers that are applicable for the inherent purpose of section 40 of the Securities Transfer Act. In order to redeem collateral on special deposit of securities into court on notice of transfer, subject to rule 19 on disposition of interest in whole, under absolute assignment by endorsement, whether special or in blank on conversion, provided here as the other document made on this. Now, this is why I put a little box on the right-hand side, made on the, for instance, 27th day of September. Please write that, the actual month in. This is all how court likes to see dates. 2024. We know there's lots of extra spaces. Leave that, please. There's a purpose for that as well. Perfected by delivery to the Minister of Finance in right of the province of British Columbia by the appropriate person having acquired a security entitlement under section 95(1)(b) of the Act. All right, and then here's where you have to do your little squigglature. There's a provision for the date to be put in there. Again, you can remove the actual signature box and insert your own, or if you print it off, you can do your signature in blue. Print again your name in blue, or you can type it in there. You're going to want to put beneficial owner holding financial asset directly. That's already been provided, and include your address below. Nice and simple. Now, these are a few little reminders and upgrades we want to give you before we close the class here today. We had a question in class number 4. What wording should a subclass member use when making application for a birth certificate to direct its delivery to the Supreme Court of British Columbia for Dïevergent's class proceeding? So we have some members who don't have birth certificates. So at the time, we were just going to have it delivered to the courthouse. That, again, option has been removed. It's no longer available. All subclass members have to complete the AAA and the Form 70 attach the birth certificate as instructed, which means you're going to have it delivered. You're already the person, loved ones. Let's just get the birth certificate, get it on that AAA, get it to us, dispose of it, and then you're done. Number 2, those wishing to join the class proceeding, again, fill out Form AAA, Form 70, your acceptance video, email it to us, and we'll have the subclass administrator take a peek at it for your approval. We want to remind you, please, Dïevergence does not have a website at this time. Please be careful of divergent posers. We have them out there. In fact, we have someone who has started a website using our name, our logo. So this is why, unless otherwise advised by the court or the subclass administrator from court, only send your information to the email above. We want to be able to give the whole email to Shannon to run, and she'll just let us, she'll let us know if we get any emails that we have to know about. So at this point, we figured that's the safest way to be able to get all this information and to protect your privacy at the same time. We're going to be posting all of these forms on our Telegram channel. We now have a main page. That one will only give you the information that Dïevergence has posted. That's where these forms are going to be. We also have a chat available so that if you want to answer any of the Telegram questions to test your knowledge, you can do so, and we will include those in the write-up below. Subclass members as well who did not add valuable consideration to their securities. In fact, we only had one subclass member who attached his silver coin. Yeah, Hayden, nicely done, bud. So for those who have not attached a silver coin on their AAA submission, are being asked to add that, you can add a silver coin, a gold coin, or a silver back stamp, and you're going to have to resubmit it. Now that we know no title moves without valuable consideration, now we see the importance of that. If you'd like to include the Red's thumbprint, because that was an addition that we added on just today, you're welcome to do that as well. Okay, so you got a little bit of time on that, but we wanted just to kind of lay all of that out for you, loved ones. We know it was a lot today, but we wanted this to be a nice, clean submission for members who don't want to join our class, who are about to lose their home and want to do this process. Here you go. We're basically wishing you the best. We are expecting wonderful results from this process. It's very nicely laid out so that you can be able to do this on your own, which is great. And if you're a subclass member, or you want to join, please send that information to Dïevergence, and we will approve it or let you know if there's anything you got to fix up.
And again, don't feel bad if you're making your video submissions and it gets kicked back and you do it again and it gets kicked back again. And you're like, crap, I gotta do it again. And it may even get kicked back again. Don't worry, that practice, at the end of the day, and we know some of you are laughing, that practice is gold. That is what builds your confidence. That's what's going to give you the ability. Can you imagine if you're talking to a judge, right? Instead of just us or just to a blank computer, it's building your confidence. And when your confidence is rising, you're becoming more powerful. And when you're entering into your power, your superpower, that's making you a superman or woman, is it not? So don't be afraid about bungling up your video 3 or 5 times. Don't worry about it.
And did you see the words that we have to speak to? They're monsters. Never mind the fact that whoever writes legislation is allergic to punctuation. They don't like commas. They're never-ending sentences where you got to take 5 breaths just to be able to get through it.
You'll see it in Gibson's book. Gibson will have a paragraph, I shit you not, this big, with like no periods in it. It's just all commas.
But you're winded when you're done.
It's one big ass sentence. It's like, I remember in grade 4, they told me that was a big no-no. Okay, well, in the real equity world, it's a yeah, if you want it to be.
Okay, so we do have a quick question because it is relevant. What happens if you've already disposed of your birth certificate as perfected in the courts?
Well, then you're probably off to the races. I'm going to ask, what was their response? If there's no response, that means we're going to have to do something else. If there was a response and it didn't feel favorable, let us take a look at it, because it may not feel favorable to you, but it may be favorable to me. Again, here's an example. One of our loved ones sent in some process and they got back saying that the court's going to do an examination. They're going to look into the matters. Ding, 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 ding. As soon as the court is doing an investigation, an examination, or an inquiry, they're looking at the facts. and they're gonna make a determination. And if they're gonna make a determination, that means that's a ruling, and a ruling is an order, which means you actually, whoever's doing it could be that far away from pulling off, a significant.
Okay, loved ones, thank you so much for joining us for equity class number 5. We're going to see you next week. We are going to be starting to focus on our subclass members to kind of prepare you a little bit more for court. So we are going to go over the Telegram questions next week. We're going to do a little Q&A. Then we're going to ask the public to leave, and we're just going to be working with our subclass members. And we'll be able to fine tune you and help polish you up where you need some work. Okay, we will see you next time. Thanks for coming. We
Hey,
love
loved
you.
ones.